My lord,
May
first I am begging pardon. I have missed the bus yesterday for mentioning two matters only, my lord. One is the, my lord,
Scope.
my lord,
Scope.
my lord, kindly, allow,
Sir,
kindly.
Unable to handle the
I
slips.
understand your lordship's
But
court
then
officer has
please
raised
explain.
another two matter. It is with regard to the recruitment. Otherwise, I shall not disturb your lordships, my lord. It is my duty to assist your lordship properly, my lord. I am.
But then it's very difficult.
It was directed to appear on 9th, my lord. It has not come. I miss.
Which
Totally
ninth?
miss, my lord. 9th of March, my lord. It was
From
filed.
see,
But
we
it
are,
was filed 23rd February, my lord.
yes.
I miss. I have not looked out the matter that it is not appearing in the list.
Recruitment CAPF.
See,
All right. Give the number. It will appear in the supplementary list.
much obliged. Grateful.
Next Monday.
Grateful.
Type notice upon the other side.
Lordship, I beg your
My lord.
permission to mention a particular matter which is of item number 49 of today's list. On the last occasion, your Lordship directed the respondent authorities to consider the application made by the petitioner to accept his resignation. Today is the date of the listing, your Lordship. If your Lordship,
Today is the date of listing.
today is the returnable date.
Huh?
So if your Lordship would be kind enough to fix a particular time schedule for my senior to appear in this case, because
Why?
9th is the last date of to file nomination and today is 7th.
Yes. What is, how is your senior so very important that a time has to be fixed? The court will run as per the convenience of the court. No time limit
Number
fixed.
49, your Lordship.
No time limit will be fixed. Yes.
My lord, I'm paying for inclusion in the list, my lord. Application, my lord.
Which list?
Group 6, my lord.
Which list? Original site?
Or Delhi appellate site.
Why did you not mention yesterday?
My lord, I could not able to enter and
I think you are wrongly submitting before the court. The court was quite empty. Come next month, please. Yes.
Your Lordship, may be permitted to mention original side matter, my lord.
For what?
For hearing.
No, sorry.
In the list, my lord.
No, no, no.
Permitted for inclusion a matter for pension matter. Petitioner is not getting the pension due to the inaction of the RPF authority.
Yes. Come next month.
Okay.
What happened, my
No,
lord?
don't say what happened.
My lord, actually, what happened?
I am not
My lord,
going to
my lord,
listen.
This is the matter, my lord. Actually, my lord, examination has been completed, physical measurement by the command hospital, which was sent by this honorable high court. Report has come. Then, my lord, fixed for order. But in the meantime, determination has been. My lord, report has come, my lord. If your lordship on any convenience, on any day, my lord, after your lordship, my lord, you taken up, my lord.
Don't mention today. Next week, I'll say. No, sorry.
May I have your lordship's leave to mention this matter for inclusion, lordship? Lordship, this is regarding.
I am not going to hear and I'm not including matters.
May be permitted to. My lord, the petitioner is facing, my lord, arbitrary disciplinary proceeding, my lord, before his promotion, my lord, to the rank of DIG, my lord. And my lord, 4 inquiry has already been conducted. And
there is a note in the list that no mentioning will be allowed. Why are you mentioning?
My lord, my employment has been terminated. Affidavits are completed. My lord, inclusion in the list.
Is there a note in the list?
My lord, I appreciate it. My lord, I missed the list.
Please appreciate.
My lord.
Call the list, please.
Item number 1.
The appear for the respondent matters. So this is the point of mandatory point, lordship. Mandatory of the writ petition, lordship. Admittedly, the respondent petition is a workman, lordship. Lordship. Before I make my submissions on the point of mandatory, lordship, I may be permitted to place the facts for short, lordship, in short, lordship. Lordship, kindly consider my affidavit in opposition, lordship, so that fact can be clear. Lordship will consider page 4 of my affidavit in opposition, lordship. Subparagraph 8, lordship.
Which page is it?
Page number 4, lordship.
Page 4.
Subparagraph 8.
Yes.
In the bottom portion, lordship. On 12th September 1994, while the writ petitioner was advised to work in SB1 counter as special assistant, in addition to normal duties, he withdrew rupees 1,300 from his own SB account number such and such by withdrawal slip dated 12th August 1994.
It will be August or September. It will be August.
Lordship,
First
August.
date is September.
Lordship. September, lordship. September.
So August is wrongly written.
Lordship, wrong written, Lordship.
All right.
But with an ulterior motive and undue monetary gain, he did not debit his account in the ledger sheet. The writ petitioner passed the
Oh, what does this mean? Did not debit his account in the ledger sheet?
Lordship, he withdrew the said amount,
He withdrew.
but did not debit in his account, Lordship. But his own account, that is not, Lordship, that is not maintained the book, Lordship.
All right.
And therefore, the writ petitioner passed the said withdrawal slip into the token register and received the payment thereof. To suppress the aforesaid acts, he removed related original ledger sheets of the concerned ledger after making fake credit entries and fraudulently withdraw against and replacing the same with new sheets.
What does he gain out of this?
Lordship, to withdraw the amount, Lordship,
Yes.
he did not make any entry, Lordship. Credit and debit, Lordship.
Yes.
He did not do that, Lordship. And he's totally suppressed that. And subsequently, Lordship, it was identified and verified, Lordship.
And that he did from his own account, not that he took money from somebody else's account.
But Lordship, there is a balance sheet, Lordship, in the bank, Lordship.
Oh, but then everything is relating to his own account.
His own account. And not only that, the other account also, Lordship.
No,
Paragraph G also there in
I am coming to that.
Lordship.
The one that you read,
Lordship.
this 1,300, he took it from his own account,
Lordship.
but he did not update the ledger.
But Lordship, that account was from the bank, Lordship. But
Certainly from the bank, but then it is from his account that he did all these things.
Lordship.
Next.
Lordship. For his aforesaid acts, the respondent bank issued a charge sheet to the writ petitioner. Subsequent an inquiry was held with regard to the said charges. In the inquiry proceedings, the writ petitioner appeared along with his co-employee, namely Deepak Sarangi, before the inquiry officer. On 9/6/1998, the inquiry officer submitted his report and found that the charges leveled against the writ petitioner stands true.
So this is the only charge. He withdrew
No,
1,000.
Lordship, another charge is there, Lordship. Another charge is there, Lordship. Thereafter, the disciplinary authority, by an order dated 25th March 1999, dismissed the petitioner from service without notice in terms of clause 19(6)(a) of bipartite settlement, Lordship. This bipartite settlement was governed, Lordship, between the employee, that is a workman, and the bank. And in respect of the officers, there the officers' regulations are different, Lordship. There are service regulations in respect of the officers, but bipartite settlement in respect of those persons who are workmen in the bank, they are covered by this bipartite settlement. This is the first bipartite settlement of the bank, Lordship. Therefore, the writ petitioner preferred an appeal before the appellate authority against the order of the disciplinary authority. It is stated that on 25th February 2010, the learned judge special court under Prevention of Corruption at Barasat, North Chennai, had been pleased to hold that the accused writ petitioner is entitled to get benefit of doubt. It is stated that writ petitioner filed a writ petitioner before this honorable court, WB number such and such, and on 14th August 2023, the honorable court had been pleased to dispose of the said writ petitioner by requesting the appellate authority to pass the reason order in the appeal. Lordship, the dismissal was, Lordship, in the year of 1999, Lordship. Thereafter, it's totally silent. And then, Lordship, order was passed from the learned judge on the ground of benefit of doubt on 25th February 2010. Thereafter, it waited for 3.
When was the appeal preferred? KL, you mentioned petitioner preferred appeal.
Lordship.
Where is the date?
The appeal was preferred, Lordship.
Why was the petitioner required to approach the court for obtaining an order for conclusion of the appellate proceeding?
Because, Lordship, appeal is pending before the bank authority, Lordship.
Why will it remain pending? And for how many years should it remain pending?
Lordship, appeal was preferred, Lordship, after the order was passed from the learned special court, Lordship, under the Prevention of Corruption Act on 2010, Lordship. And,
all right.
And he preferred an appeal to consider that judgment.
All right.
Lordship.
He was dismissed in March
1999, Lordship.
In February 2010, that means within less than a year, the
Lordship.
criminal proceeding concluded.
Lordship.
Thereafter, he preferred the appeal. And from 2010, it remained pending till 2023.
Lordship, he has filed the writ petition in the year of 2012, Lordship. During pendency of this writ petition, Lordship, the bank did not take any steps because the matter is sub judice before this honorable court, Lordship.
What was there any stay order not to consider the appeal?
No, Lordship.
Because that was the prayer of the petitioner to consider and dispose of the appeal.
No, Lordship. And that was not the order, stay order, Lordship. There is no stay order obtained by.
No stay.
No, Lordship.
So you sat tight over the matter for so many years. Next. Then
Therefore, in terms of the said order, Lordship, on 14th August 2023, passed by the Honorable Court, the appellate authority by an order dated 16th of February 2000 rejected the appeal filed by the writ petitioner, Lordship. Next, it is stated that the petition was dismissed from service on 25th March 1999 when the criminal case was pending before the learned Special Court under Prevention of Corruption Act, Barasat, North Chobbish Parganas. It is stated that the departmental proceeding and the criminal trial are two different things. In the departmental proceeding, the sophisticated rules of evidence does not follow. The departmental proceedings are conducted by the quasi-judicial authority. Next, on the page 7, it stated that during the inquiry proceedings, fullest opportunity was given to the writ petitioner to defend his case. The writ petitioner also submitted defense exhibits and before the inquiry officer he duly appeared along with his co-employee. From the above facts and circumstances, it is stated that there is no violation of principle of natural justice in the disciplinary proceeding. And next, Lordship, point of mental point, Lordship, kindly see paragraph R, page 7. It is an admitted position that the writ petitioner was a general clerk. Therefore, he is a workman under section 2S of the Industrial Disputes Act 1947. The learned Central Government Industrial Tribunal is the appropriate authority to adjudicate the disputes of the writ petitioner. The said writ petition should be dismissed on the ground of existence of alternate remedy. The writ petitioner directly approached before this honorable court. Therefore, this honorable court may be pleased to dismiss the said petition on the ground of existence of alternate remedy. Now, Lordship, kindly see.
no, prior to that, you show me one thing. What is the other charge that you said? One you read out that he withdrew 1,300. What is the other charge?
Lordship, page 3, subparagraph F, Lordship. It is stated that the writ petitioner during his service tenure as general clerk, one government has forthscribed 5 fictitious credit entries of rupees such and such, each totaling of rupees 11,000 and odd, without any instruction in SB ledger number 69 relating to SB account number such and such standing.
1 minute.
Names.
1 minute. 1 minute. 1 minute. 1 minute.
Lordship.
Page 3.
Lordship.
He was a general clerk
Lordship.
and he forged scribed 5 fictitious credit entries of rupees 2,241, each totaling to rupees 11,000. What does this mean? Entries of
5, Lordship. Entries of 5.
5
5.
credit entries of rupees 2,241, each totaling to rupees. What does this mean? 2,241 you have said.
Into 5, Lordship. Totaling.
Then not each.
Lordship. Then maybe not typing.
Acha, 2,000 each totaling to rupees. All right.
Totaling.
Without any
instruction in SB ledger number such and such, relating to SB account number such and such, standing in the names of Sri Ananda Chandra Mondol and Sri Sanjeev Mondol. In a similar manner, the again forged and scribed 5 fictitious credit entries of rupees 2,000 each on 7th April 1994, totaling 10,000. In the same ledger number 69 relating to SB account number such and such of Srimati Charu Mondol. Subsequently, the writ petitioner fraudulently withdrew and received cash under his signature for an amount aggregating of rupees 20,435 on different dates from the aforesaid 2 savings bank accounts against the fictitious credits made by him with the help of withdrawal slips, all under 4 signatures of the respective accounts holder. Not only for his own lordship, there are other occasions as their lordship, and is doing it repeatedly, lordship.
All right, then, yes.
Lordship, kindly see, lordship, page 7, lordship, paragraph R, lordship. Now, lordship,
are you read out?
Lordship, lordship, the order was passed in terms of the settlement, lordship. Lordship will find page 12 of my opposition.
Yes.
In the middle portion, lordship, paragraph 6.
Yes.
All considered, I find that the proposed punishment of dismissal without notice in terms of clause 19.6a of bipartite settlement dated 19th October 1966
Hmm.
has been just and proper in view of the misconduct which is of grave and serious nature proved against you.
Hmm.
These bipartite settlements clearly mentioned, Lordship. Now, Lordship, kindly consider,
Show me that the settlement is only applicable in respect of workmen.
Lordship. Lordship, this is the, maybe permit to hand over, Lordship. This is the last settlement, Lordship.
Hmm.
আপনি জানেন সব কিছু দেখছি memorandum of settlement dated 10th April and 27th May. Lordship, kindly consider page, third page, in the bottom portion, Lordship, page 130.
Hmm.
Lordship, in the top portion, Lordship, kindly consider memorandum of settlement dated 10th April 2002 between the management of 52A class banks as represented by the Indian Bank Association and their workmen as represented by the All India Bank Employees Association, National Confederation of Bank Employees, Indian National Bank Employees Federation, under Section 2P and Section 18(1) of the Industrial Disputes Act 1947, read with Rule 58 of the Industrial Dispute Central Rules 1957. Lordship, kindly see name of the parties clearly mentioned. Thereafter, Lordship, representing the employers, members of the bank. Thereafter, Lordship, will find duly authorized on behalf of the Indian Bank Association in the left-hand side representing the workmen. And Lordship, this settlement was made pursuant in terms of the provisions of the Industrial Disputes Act under Section 2P and Section 18 of the Industrial Disputes Act. Let I answer, Lordship, the relevant provision. Lordship, kindly consider short recital of the case, Lordship, page 132. Subclass A, Lordship. In respect of 52A class banks listed in the schedule to this memorandum of settlement, except the SBI, State Bank of Saurashtra, Indian Overseas Bank, and Bank of Baroda, provisions of para 521 of the Shastri Award as finally modified and enacted by the Industrial Dispute Banking Companies Decision Act 1955, the Industrial Disputes Banking Companies Decision Amendment Act 1957, and the provisions of para 18.20, 18.24 and 18.28 of the award of the National Industrial Tribunal presided over by Mr. Justice K.T. Desai in reference number such and such, which award inter alia modifies certain provisions of Shastri Award, hereinafter referred to said award as modified by the settlement dated 19 October 1966. Lordship, he was governed by this settlement. That is why, Lordship, I am pointing out, Lordship. Settlement of 19 October 1966, subsequently, Lordship, next 31st October 1979, 22nd November 1979, 8 September 1983, 17 September 1984, and 14th February 1990 were governed the procedure for taking disciplinary action against the workmen in these banks. Thereafter, Lordship, kindly see the next page in the middle portion, Lordship, in the bold terms of settlement. The provisions of the said awards, the first bipartite settlement, Lordship, I have already mentioned, Lordship, first bipartite settlement dated 19 October 1966, and other subsequent settlements dated such and such, hereinafter collectively referred as the said settlements shall stand superseded and substituted by and in the manner detailed herein. So this is the last settlement, Lordship, and in that settlement clearly it is mentioned, Lordship, the first settlements also. Now, Lordship, kindly see page 147, Lordship. This bunch, Lordship. The schedule 1, Lordship. Your Lordship, kindly see in the top, Lordship, said page, list of banks. Lordship, kindly see column number 18, United Bank of India. He was the employee of the Artstal United Bank of India. Now it was merged with effect from 1st April 2020 with Punjab National Bank, Lordship. And Lordship, we'll find column number 13, the name of the present bank, Punjab National there, Lordship. Now, Lordship, kindly consider section 2P of the industrial dispute, sir. In the left hand side, Lordship. Settlement means a settlement arrived at in courts of conciliation proceeding and includes a written agreement between the employer and workmen arrived at otherwise than in courts of conciliation proceeding where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof has been sent to an authorized officer on this behalf by the appropriate government and the conciliation officer. Now, Lordship, in terms of this provision, Lordship, the settlement was arrived at between the parties. Now, Lordship, kindly consider section 18, Lordship, 180. Persons on whom settlements and awards are binding. A settlement arrived at by agreement between the employer and workman, otherwise than in courts of conciliation proceeding, shall be binding on the parties to the agreement. That means of this agreement, this bipartite settlement is binding upon the parties because he's a general clerk. He'll fall under the category of section 2S of the Industrial Disputes Act. Now, also kindly consider section 2S, the workman, definition of the workman.
Yes.
Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work. Clerical, he's a general clerk, Lordship. Supervisor work for higher reward, whether the terms of employment be expressed or implied, and for the purpose of proceeding under this act in relation to an industrial dispute, includes any such person who has been dismissed. This person dismissed, Lordship. Dismissed, discharged, or retained in connection with or as a consequence of that dispute, or whose dismissal, discharge, retention has led to that dispute, but does not include any such person. This is the Lordship exclusion, Lordship, who is subject to the Air Force. Second, who is employed in the police service.
Yes, yes.
Lordship. Now, Lordship, from this settlement, from this bipartite settlement, he is the workman, Lordship. There is separate provisions under the industrial forum, Lordship. Industrial tribunal is the appropriate authority to adjudicate the dispute, Lordship. Lordship, already paragraph 2 are in my opposition, Lordship, are clearly mentioned, Lordship. And settlement, in the bipartite settlement, the sections, relevant sections also mentioned, Lordship.
What does 19.4 of the bipartite settlement say?
19.4, Lordship.
Because relying on which you pass the order?
19 October 1906.
No, 19. I do not know. 19
19
October
October
19.
19, this is the first settlement notice.
Yes.
This is the first settlement.
Point of time, it was not in the private, it was in the private sector. 1906 of the first settlement. The disputes are governed by the settlement orders. 19, an employee found guilty of misconduct may be dismissed without notice, be wanted or censored, or have an adverse remark entered against him. We find, have his increment stopped, have his misconduct condoned, and be merely discharged. That's all. There is only one.
A little. Keep it.
This that settlement lordship, and subsequently this settlement was superseded and modified by this large settlement lordship, 10th April 2022 lordship. And therefore, lordship, in terms of this lordship, settlement lordship, his admin, his workman lordship, his alternate remedy is under the Industrial Disputes Act lordship. He should approach before the Industrial Tribunal lordship, but he directly approach before this writ court lordship. After passing the order from the criminal court lordship, he preferred an appeal, and for during pendency of this appeal lordship, he filed this application, writ petition lordship, and by an order dated such and such lordship, his lordship on lordship is directed to consider to have rejected the appeal lordship. But from the date of dismissal, since 1999 lordship, is sit idle lordship till 2012 lordship. He was waiting for the judgment of this criminal court. As benefit of doubt, that's why lordship he preferred the appeal and approach before this honorable court earlier in the year of 2012 after expiry of 13 years. Sir.
First writ petition filed in 2012, isn't it?
2012 words. After expiry of 13 years, Lord.
Yes, I understand. All right.
Lordship, on the point of Industrial Disputes Act, Lordship, may I be permitted to, Lordship? Honorable Apex Court judgment, Lordship, kindly elect paragraph 13, Lordship. 2006 5 SCC 469. So kindly consider paragraph 13. It's clearly mentioned, Lordship.
Here it mentions as disputed questions of facts were involved. What is the disputed question of fact over here?
Under the ID, available under the idea. Lordship, he may challenge that dismissal order, Lordship, because in tribunal, Lordship, there is a provision, Lordship, to claim and counter claim and also to
No. See,
Lordship.
the judgment that you relied upon, the paragraph specifically mentions as disputed questions of facts were involved.
Lordship.
In the present case, is there any disputed question of fact? No.
In this case, there is no dispute of fact, Lordship.
Then how are you relying upon this?
Because also, this is the related to under the Industrial Disputes Act, Lordship.
That is different. You've got several other judgments.
Lordship. And also another unreported judgment of this coordinate bench, Lordship, another coordinate of this honorable court, Lordship. May I permit to hand over?
Can I have a copy?
That's আপনার কাছে আছে ইন্দ্রনীল বোস
Indian question here.
বিশ্বনাথ সমুদ্র justice.
No, issue decided over here.
because he's a workman.
No, but then
And
this was not even objected to.
on the first it was rejected, Lordship, on the ground of mentally point, Lordship. We have raised this
Yes.
on the first day, Lordship. The learned advocate for the bank Lords raised that dispute. That admittedly he was a workman.
There was no submission made over here as regards the choice of the petitioner to choose either between the tribunal or the writ court. The
In that case, Lordship, directly he approached this honorable court, challenging the dismissal order before this honorable court, Lordship. And on the
yes.
first day, Lordship, we raised this point that he is a come under the purview under section 2S of the Industrial Disputes Act. He is covered by this bipartite settlement. And on that day, Lordship, it was dismissed. There are no appeal was preferred. Now that dispute is pending before the Central Government Industrial Tribunal.
Yes. Anything else?
On the point of mental bond, this is my response.
What are the other points that you have? Do you have anything else?
Must be address merit and as well as
Yes, yes. Because he has addressed on both.
Lordship.
So you make all your submissions. I'll pass necessary order.
Lordship, he duly appeared before the inquiry officer, Lordship, with his co-employee, Lordship. There is no violations of the principle of natural justice, Lordship. I've also raised my point, Lordship, in the opposition, Lordship. Also,
Yes, yes.
And secondly, Lordship, his gross misconduct, Lordship, not only for his own savings account, in respect of the others, there's repeatedly misconduct on his part, Lordship. And in a banking organization, Lordship,
But the your allegation of forgery,
Lordship,
fake documents, these have not been accepted by the criminal court.
But Lordship, if your Lordship kindly consider the judgment, Lordship,
Yes.
Lordship, kindly see page 63, Lordship. He got benefit of doubt, Lordship, not the honorable acquittal or acquittal, Lordship. Kindly see page 63, Lordship. In the top, Lordship, I have no hesitation to hold that the prosecution has failed to bring home the charges against the accused beyond any shadow of reasonable doubt, considering the accused is entitled to get benefit of doubt. After this, Lordship, he preferred an appeal. And a criminal case and the departmental proceeding, Lordship. In departmental proceeding, sophisticated rules of evidence does not follow. That's honorable.
Give those judgments?
Yes, Lordship. Yes, Lordship. Lordship, may be permitted to hand over the entire compilation. Lordship, kindly.
Lordship will kindly consider page 99 of my compilation.
Hmm.
And straightway comes page 102. Which sorry.
Will you rely upon all the judgments?
All the judgment, Lord. All the judgment, Lord.
The compilation that you handed over, you'll rely upon all.
Because Lordship, point of entry, first three judgment relates to the point of entry, Lordship. Whatever.
All right.
And thereafter, Lordship address.
1 minute, 1 minute.
Lordship.
These three are maintainability issue.
1 to 3, Lordship. 200. And thereafter, all subsequent judgment are on merit, Lordship.
On merit.
Lordship.
All right. This one is 99.
Lordship kindly comes to page 102. In the left portion, extremely Lordship, bottom Lordship. Extremely bottom Lordship. It is well settled that in a domestic inquiry, the strict and sophisticated rules of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for total mind are permissible. There is no larger to hearsay evidence provided it has reasonable nexus and credibility. Therefore, Lordship, kindly see my compilation, page 11, Lordship.
Page 11.
Lordship, page 11,
Right.
my compilation.
Lord,
straightway comes to Lordship, paragraph 22, Lordship. Now, so far the submission on behalf of the respondent delinquent officer that as he has been acquitted in a criminal court and therefore he cannot be held guilty in disciplinary proceeding is concerned, the aforesaid has no substance. From the judgment and order passed by the criminal court, it appears that he has been given the benefit of doubt. In this case, Lordship has also benefit of doubt, Lordship. Even otherwise, the standard proof which is required in a criminal case and that of the disciplinary proceeding is different. The fact that the criminal court acquitted the respondent by giving him the benefit of doubt, again, Lordship, same language.
all right. Then
Lordship will find page 21, my compilation, Lordship. State Lordship will come paragraph 17 and 18. Lordship will find page 23.
yes.
While exercising jurisdiction under Article 226 of the
Page 23
Lordship,
or paragraph 23.
paragraphs, page 23, paragraph 17 and 18, Lordship.
There are so many paginations.
Lordship, in the top page 23 and 29, Lordship.
You tell me the paragraph number.
Paragraph 17, Lordship, 17.
17. While exercising.
While exercising jurisdiction under Article 226 of the Constitution, the High Court does not act as an appellate authority. Its jurisdiction is circumscribed by limits of judicial review to correct errors of law or procedural errors leading to manifest injustice or violation of principles of natural justice. Judicial review is not akin to adjudication of the case on the merits as an appellate authority. Therefore, Lords, in B.C. Chaturvedi v. Union of India, the scope of judicial review was indicated by stating that review by the court is of decision-making process, and where the finding of the disciplinary authority are based on some evidence, the court or the tribunal cannot reappreciate the evidence and substitute its own finding. Thereafter, Lords, will find page compilation, page 31, Lords. Paragraph 5, Lords. In the bottom portion, Lords. In view of the submissions made at the bar, we have scrutinized the impugned order of the High Court. A bare perusal of the same makes it crystal clear that that High Court in exercise of jurisdiction under Article 226 has reappreciated the entire evidence gone into the questions of burden of proof and onus of proof and ultimately did not agree with the conclusion arrived at by the inquiring officer, which conclusions was upheld by the disciplinary authority as well as the UP Public Service Tribunal. It has been stated by this court on a number of occasions that the jurisdictions of the High Court under Article 226 is a supervisory one and not an appellate one, and such court would not be justified in reappreciating the evidence adduced in disciplinary proceeding to alter the findings of the inquiry authority.
Yes.
Thereafter, Lordship will find page 34. Lordship kindly consider paragraph 2. Paragraph 2, Lordship, page 35, Lordship, in the middle portion, Lordship. I cannot much more trouble to you, Lordship. The banking business and services are also vitally affected by catastrophic corruption. The disciplinary measure should therefore aim to eradicate the corrupt proclivity of conduct on the part of the employees stroke officers in the public officers. Lordship, kindly see in the judgment also, employees and officers. Officers for the separate regulation, officers employed to come under the bifurcation the workmen. Officers of the public. It would therefore be necessary to consider from this perspective the need for disciplinary actions to eradicate corruption, to properly channelize the use of the public funds, the live wire for effectuations of socio-economic justice in order to achieve the constitutional goals set down in the preamble, and to see that the corrupt conduct of the officers does not degenerate the efficiency of service, leading to denationalizations of the banking system. Therefore, Lordship, kindly consider page 47. TJ Paul. Lordship will consider Sabit.
Yes, I get it. Everything is in the same line.
Lordship. And there is also that's all the judgment order, Lordship.
All.
Paragraph mentioned. This is my respectful submissions.
All right.
The merit as well as, Lordship, the point I made.
Yes.
One thing, the appeal was preferred in 1999. Grounds were not given, but the appeal was preferred in 1999. It was not disposed of. Then in 2012,
The dismissal was in 1999. The criminal court acquittal came in 2010.
appeal was also filed, departmental appeal was filed in 1999, not in 2010 or 2012.
All right.
And
So
it's
that
filed-
was within time.
All
It
right.
was kept pending.
All right.
2012, I preferred the writ petition so that the appeal is disposed of. That is the main thing. And this, Millard, this 19.6, which he pointed out, that was long back superseded. If your lordship wants, I can show you.
No, this one has been shown. It has been superseded.
It has been superseded.
clearly-
long
No,
back.
but then
Yes.
the employee, this definition remains, and the employee is covered by the Industrial Dispute Acts. That also remains.
Millard, I will.
99 may be superseded.
Yes.
That
No,
the
99
60
was
66 may be superseded. But it,
correction was that the only correction is that the appeal was preferred on time. It was no
Yes.
latches. on
all right. That,
Number two is that 2Q. This is I have cited judgments before your lordship to show that if it is also without jurisdiction, your lordship has a jurisdiction.
but then without jurisdiction, you did not.
It is without jurisdiction because 19.4 is absolutely this. My first submission was that the writ petition.
Bipartite settlement will
Yes,
not be
it
applicable.
violates. 19.4 is violated by this keeping this order of the disciplinary authority intact. Because after acquittal from the disciplinary proceeding, there cannot be that order cannot stand.
No, 19.4, just show me 1 second where
Yes, 19, the book.
you handed over a book.
Yes, I have handed over the
1
copy.
minute.
Yes, yes.
Hmm.
19.4, if your lordship sees, and if your lordship compares the appellate order,
Hmm.
it violates the bipartite agreement itself. Once there is a violation of that, since he says that we are all bound by it,
Yes, 19.4.
yes. If he be acquitted,
Yes.
then, my lord, the consequences are there. And if your lordship sees the order of the disciplinary authority,
No, just place 19.4 once again.
your lordship trying to keep it. I have not brought that book. I'll just.
Is this the portion that you're relying upon? দেখেন তো এটা, 19.4.
Because this is C,
Hmm.
19.4 C.
Hmm.
If he be acquitted, what are the consequences that?
Yes, if he be acquitted.
Yes.
Yes.
Then, Millard,
Uh,
he can't be dismissed without notice. And I've made an elaborate submission on that. I've shown your lordship also that he's entitled to pension benefits.
Hmm.
So that order itself is without jurisdiction and in violation of the bipartite agreement. And the judgments of the Honorable Supreme Court are all on this point. And number two is, he says 2P.
Yes.
If your lordship notices 1995 Supreme Court, which I pointed out before your lordship, it does not have, and the sister acts. This is not a certified standing order. This is a settlement where the choice comes in. Election. I can elect and substantially say he does not say that the criminal charges and the proceedings in the criminal court and the charges before the departmental inquiry are the same. That is what he says himself. That is, I have alleged that in paragraph 8 of my writ petition. Paragraph 8 of my writ petition. No, reply to paragraph 10. Paragraph 10. Paragraph 10 of my writ petition, will it?
Yes.
And if your paragraph 10,
Mm-hmm.
if your lordship sees. And it is the same. Those are the only charges that were leveled against me. That is also before the criminal.
1 minute. Paragraph 10, the appeal was heard by the appellate authority.
Yes.
Huh?
On the face of it, the appellate authority had the advantage of the judgment of the special court acquitting the petitioner of the same charges on which the petitioner had been found guilty in the departmental proceeding. The appellate authority could clearly see that none of the persons of whose accounts were alleged to have been tampered ever affirmed such in the criminal proceeding. They came before the criminal court. They came before the criminal court. And here he says, he doesn't even say no to it. It's substantially the same. And anyway, in the departmental proceeding, and bipartite goes one step ahead. It says that if he be acquitted in the criminal proceeding, we don't even need any judgments for that. It's the binding nature of the bipartite agreement, which he says, yes, of course. Paragraph 8, he says. Paragraph 8 in his reply, he doesn't controvert it. Bipartite agreement says it's the same set of charges. You are being tried. And if your lordship wants, I can even expatiate on that.
Very well. Please come.
Yes.
Learned advocate representing the bank commences and concludes argument. Stop. The petitioner has replied to the same. Hearing concluded, CAV.
Deeply obliged.
Don't call any other matter.
My lord, I am praying for a short Passover.
On behalf of whom?
I am from state.
My lord, I am being led by Mr. Deepan Kumar Sarkar, my lord, in this matter. I am not opposing the Passover, my lord.
I am for the respondent number 8.
I am for
the respondent number 7.
My lord, this matter is coming up at my instance, lordship. I had mentioned the matter. My lord, the petitioners are all data entry operators working for the State Legal Services Authority, the High Court Legal Services Committee, and the DLSAs. Well, they are headed by the respective judges of this honorable court, who had engaged these workers on a contractual basis. Subsequently, their services were taken over by the state government, because as per the Legal Services Authorities Act, these employees are entirely the responsibility of the state government. They may be under the administrative control of the High Court, but their service conditions are entirely under the control of the state government. In 2020, the state government came out with a notification where such data entry operators all across the board in all establishments controlled by the state government, they would be entitled to a service tenure till retirement and certain pay benefits and basically a security of tenure. This was not
in
2020. And that has been supplemented in 2024.
All right.
Now, as a matter of default, these particular persons were covered because their service had been admittedly taken over by the state government. Their service every year is being renewed by the state government. And therefore, the learned judges, through the member secretary of the SLSA, of this honorable court had written that kindly apply this kindly give effect to this notification, because there was never any dispute that this applies. All these persons, since for the last 8 years, getting a measly salary, which is 8,000 plus certain benefits, which comes to around 13,000. Till date, no response. But then there was a rejection. One line rejection saying, we regret we cannot make this applicable. Malad, a writ petition was filed. The writ petition was allowed. And the concerned departments of the state government, the judicial department and the personal department, were directed to take a decision on this claim. Malad, the petitioners were represented, the SLSA, HCLSC, they were also represented. Submissions were made. The judicial department of the state has come to a categorical finding that they are within the control of the state government. Therefore, as a matter of default, it should have been given effect to. In the middle, Lordship, the finance department gives a one-line answer saying they are not covered, and it's rejected. Now, against that, Lordship, we have come up before your Lordships. Malad, they've been suffering for a very long time. Malad, despite them belonging to our very own institution, Lordship, we've not been able to do anything for them. There was a threat that because they've taken this up with the encouragement of the SLSA, their contracts would not be renewed. We had to file an...
Are they renewed on regular basis?
Every year, Lordship, it's renewed. It was
renewed
for a year.
For a year.
For a year without any change in their conditions and no change in their benefits. But the same thing. Malad, this year also that threat came because they approached the court. Malad, we filed a CAN application, Lordship. Upon filing it, now retrospectively, it's been renewed for 1 year.
Right.
But Lordship, the point is, Malad, this issue should be decided. It's as simple as that. Malad, the competent department of the state has reached a decision. It's there on record. How can they now deny me the benefit?
Yes. Why is the matter pending in that case?
Malad, because we've mentioned it before the concerned benches, Lordship, for hearing. Malad, somehow
oppositions and everything are on
everything
record.
is on record. Everything is complete, Lordship. The point is as simple as this. There's no other point involved.
Very well. Yes.
Lord, I appear for the SLSA.
Supporting the petitioners.
But I'm for the Calcutta High Court Legal Service Authority. I'm supporting that.
Supporting the petitioners.
And also, but I show certain document by which the government has extended the benefit to the other staff and employee of the SLSA and the Calcutta High Court Legal Service. The same benefit has been extended, which was not extended to the petitioner.
Petitioners are deprived of that.
Well, if you also can see just only one document.
Yes. 1 minute. Keep it with you today.
My lord, a short passover.
No passover. It's a to be mentioned matter. You seek for a passover.
My lord, a very short passover, my lord.
Please come. And the matter is ready for hearing. List for hearing on 8th of May.
Well,
Yes, next.
Lordship, any priority, Lordship, these gentlemen have been suffering for very long. One group singled out, but with the maximum burden of the work. Lordship knows that everything is being done by these people because they are the ones who actually do the entry of all the data in the systems. Well, it's some priority if my lord is pleased to.
All right, let it appear. I'll see.
Grateful, Lordship.
Yes, two.
Much.
Yeah. In item number 2, my senior Subhosaji Chatterjee will address virtually.
My lord, I am appearing, my lord, online. I am appearing for the applicants, my lord, in item number 2, my lord. On the last occasion, my lord, this is case of my lord Arban Subujaya. Mr. Dashgupta was arguing. I am for the applicants, my lord.
My lord, the Union of India was to take instruction as to the implementation of restoration of.
My lord, I have sent my lord email along with the copy of the petition downloaded from Sarthak, and the petitioner provided all the documents and all orders, my lord. Till date, my lord, there is no response from any department of Union of India. Your lordship kindly pass one strict order so that we can, with coordination with the Ministry of Law, we can send my lord the order and to ask them to take immediate. But my lord,
you have been engaged through the Ministry of Law, isn't it?
Yes.
Then?
No, we have sent individually to the department, my lord. I mean, but this time, my lord, I'll ask the Ministry of Law to coordinate. Otherwise, my lord, all are, my lord, moving somewhere in
All right, that
election,
the
my lord.
union will do. What is
My lordship, there was a direction to recover the cost. So this is this is the communication between the CTO and the district magistrate.
Yes.
Dated the 30th of March, which reads
this
as
must be in respect of only one.
one Millennium Park. Yes.
That apart,
Because
what
in
about
this
the
was
rest?
specific direction related to that specific property.
What
And
about the
progress
rest?
report was also called for, and a hearing is scheduled to be taking place on the 17th for 2026, which is to 6 illegal unauthorized constructions. Nakul Sardar, may I please place it on record? So this is what is the progress.
And what is the extent of construction over here? How big? Only garages and only walls.
No, lordship. If I may, if I may kindly humbly beseech your lordship, even to the urban suburb, which is considered to be the largest residential complex, which every time my friends have brought to your lordship's kind notice, we have served them notice also. We have called them time and again.
Nobody has turned up.
No one turns up.
Very well. Why don't you pass order? Why are you waiting? How long will you wait?
I will take specific instruction on this.
Again
Most
instruction?
most probably there should have been some development which I am currently, because of that respective property, maybe I am currently unaware.
See what this document, this notice mentions. In compliance of such and such, provided you are hereby provided with an opportunity of hearing on 17th to justify your action of making unauthorized construction of boundary wall. So I knew it will be only the boundary wall and not the main construction.
Lordship, this kindly allows this hearing to be concluded on the 17th. We will come up.
Please move beyond the boundary wall inside the structure and don't stick to that. And I want to see the fate of the hearing.
Yes.
To the unauthorized persons who have made the constructions, persons responsible for making the unauthorized construction, the fate of the hearing. You said hearing is going on.
17th.
No, this is only in respect of 5. 6.
6.
There must be others. In the meantime, you all have heard or you all have not heard anybody?
In the meantime, your lordship, I don't know, because most of the officers are given election duties. So I am unaware
Election
of that.
is only for these 2 months. This
Lordship,
matter is
kindly-
pending for the last 3 years.
I very most respectfully submit before your lordship that kindly bears with me till this time, because most of the officers, I believe, are out on election duties.
All right, please come. Who are you
I have an
representing?
application. CAN number 9 of 2026. And my application is on a completely different genre, Lordship.
Your application?
My application is on a completely different genre, Lordship.
Who are you?
I'm one of the applicants, Lordship. I have a
Yes.
land. Land does not come within the definition of a wetland under the union rules. And there is this West Bengal rules which says that if you want to build a construction on a land, what you have to do is this: you will have to apply on a particular form. Now, this particular form is not being provided. This is on a complete misinterpretation of the union government rules. Lordship,
Yes.
could I possibly?
No, but then no, you say that without getting the form, you could not make the application.
No.
And then did you raise the construction?
No, I didn't.
So why are you here?
No, because the permission is not being given.
So that is a
so
fixed cause of action. Why are you here? Why will your application be entertained at all?
Yes, it's
You
within
are-
the definition of wetlands. It's within the wetland area. It's being managed by them, the EKWMA.
You are making contrary submissions. You say it's not a wetland. You say it is within the wetland area.
It's even if within it falls within the wetland boundary, it does not become a wetland, Lordship, under the rules.
There is a specific schedule in the act itself.
Lordship, I have gone through the schedule.
Well, then it's all right.
I have gone through the schedule, even
No,
if it falls within the schedule.
And if you're not getting an application, then
Nothing can be done. There is a specific order. It cannot be
Lordship,
done.
kindly
Please
looks
come.
at
Your
Well,
application. will be on record.
My
Please
lord,
come.
may I only indicate one thing, my lord? My applications are
That
pending.
case kindly dismisses the application.
No, sorry, sir. Things are not so easy. The matter is pending
My
for the
lord,
last 3 years,
No, my
and you come
application.
up with. I am no. If your application is there, it will remain. Yes.
There has been
my lord, I made some applications, my lord. My applications for additional
Yes.
parties are
Now they
pending, my
will
lord.
come up.
no, my lord, claiming that they fall, notice has been served, they fall within the wetland. I have read, my lord, at least those persons, what happened to those persons? Their
Yes,
advocates
yes.
also received notice, my lord.
Yes,
At least
this is what I am mentioning. Learned advocate representing the Union of India submits that despite request, comma, no instruction has been provided by any of the departments of the Union of India. Step paragraph. Let notice be served upon the ASGI for ASGI for with a request to get proper instruction from the respective departments of the Union of India who have been implemented in the instant writ petition. Stop. The learned advocate for the Wetlands Management Authority has relied upon a notice dated 1st of April 2026 issued by the Chief Technical Officer to 6 persons, mentioning that a hearing is scheduled on 17th of April 2026. Stop. It has been submitted that several hearing notices were issued earlier to the persons responsible for making unauthorized construction over the wetlands. Stop paragraph. The Wetlands Authority is directed to produce the fate of the hearings conducted by the authority. Stop. Next. Release the matter for further consideration on 11th of May.
Lordship, will your lordship consider my applications today or it will be kept pending for the next
All
occasion, my lord?
applications will remain pending. Acha, one more thing. The notice dated 30th March 2026 from the Chief Technical Officer of the Wetlands Management Authority to the District Magistrate and District Collector with a request to provide the expenditure incurred for demolition of the unauthorized construction. And the steps taken to recover such expenditure. Filed in court today be written with the records. The reply by the District Magistrate and Collector to the aforesaid letter dated 30th March 2026 shall be placed before this court on the urgent date. The reply.
Lordship, may I read a few lines beneath that? Your action of making unauthorized construction of boundary wall on RS this.
Yes, I've
jail
seen
number
that.
38 under PS Kolkata Leather Complex, District South 24 Parganas, failing which an ex parte order will be issued. So
I want to see those ex parte orders.
This is
Let the ex parte orders come
from your lordship. I think we have tried to do that also.
Let us see the result. Next.
Beyond the boundary.
I'm grateful, your lordship.
My lord, item number 5, I appear for Life Insurance Corporation. This is related to that matter I was arguing yesterday. My lord has kept the main matter in monthly list of me. Same issue, revision of pay, where we have been arguing.
Party is the same.
But, the petitioner is someone else, but the issue is
Petitioner is someone else.
For the petition.
So, my lord, what I was
No,
suggesting,
let me just make my submission. Thereafter, the suggestion would be there before to your lordships. My lord, this matter, my lord, what happens here? My lord, the petitioner before your lordship is the development officer of the LICI. So, my lord, who has been, my lord, initially, my lord, given with the order, show cause under a particular rule, the wires of the particular rule, my lord, has been challenged in successive matters all over the country and is pending right now before the Honorable Supreme Court. So, my lord, now what happens, my lord? There has been, my lord, the notification from the government of India that there will be a wage revision, or, my lord, there will be, my lord, inflation of the wage, my lord, that will be given. In that particular notification of the government of India, that gazette notification prescribes person who have been terminated in the service will not be given with the benefit of wage revision. So thereafter, my lord, what happens in 2024, the LICI my lord, issued an office order. My lord, the notification has been issued in the parliament, an office order by saying that the persons who have been enjoying interim orders from different honorable courts will not be given with the benefit of wage revision. My lord, that particular order was challenged by this honorable before this honorable court in this writ petition and the other matters as well. In another honorable court in Kerala as well. So, my lord, that particular 20 of that particular clause which says that it is putting some embargo, my lord, in file doing this, but it has been already set aside of 2021 by Honorable Kerala High Court. So now, my lord, another writ petition was pending before this honorable court, which was heard, and my learned friend on the earlier occasion, my lord, has already taken your lordship, my lord, to the order that has been passed by the honorable coordinate bench, which is affirmed by the honorable division bench. My lord, I will not repeat this. What I was just, my lord, taking your lordship to, that after this, my lord, they themselves said that from now on, the instruction that we have given that we will not be granting the benefit of wage revision to those persons whose cases were pending, we are withdrawing this. Or from now on, we'll be giving this particular thing to everyone, irrespective of the fact whether the cases are pending or not. So that has been, my lord, annexed in the writ petition itself. Kindly seize
This
that.
was not there in yesterday's petition.
Yes, my lord. I just could take your lordship to this. Or page number 121.
Yes.
My lord, I have already seen that notification. I will not take your lordship to that one. So, lordship, it is not my place, my lord. It is noticed that some of the development officers who attract termination under the provision of the special rule of 2009 of such and such and get stay order from the court of law, the show cause notice termination letter of such and such currently as informed by the different officers. Many such matters are sub judice in the various courts of law by virtue of such stay orders issued by the courts of law. All the petitioners, development officers attracting termination under the work norms continue to be on the roll of the corporation as employee with the same basic pay and allowances as that he or she was drawing on the date of the stay order. In view of the above, you are requested to note that such development officers, petitioners are to be treated alike or equal with the other development officers against whom no proceeding under the provision of Rule 2009 as amended from the time to time are initiated. And therefore, the business performance of these development officers shall be reviewed under the provision of the special rule of 2019 as amended to such and such arisal after the stay order. The appropriate annexure shall be issued. And instruct these officers to the jurisdiction accordingly and ensure that the appraisals of such development officers are reviewed every year regularly and appropriate annexures are issued. So this is.
So relying on this, you want the revision of pay.
Yes. And at least, my lord, as an interim measure, which is already done by this honorable court, and my lord, which is affirmed by the honorable division. This is my prayer.
Interim order is?
My lord, interim order to pay the revision, my lord, pay revision, benefit of pay revision to the incumbent till the writ petition is heard. So, my lord, that was challenged by the LICI before the honorable division meant that this interim order
amounts to
and
disposal of the writ petition.
Kindly
Anyway.
seize, my lord, once the order.
No, yeah, this notice was possibly not shown yesterday or not annexed there.
My lord, just keeps the matter after one day, my lord. Let me take instruction on this as well.
This writ petition was filed
my lord, very well. In that
And
event, my
that was
lord,
there
I'm
in the
still
petition.
urging the point of maintainability
Let
kindly.
him part the
No, that is different. But then this
But
is
okay, maintainability, however, my lord, still comes in this because this is an issue which is beyond the scope of the writ petition. Because this is
so
a
you mean
decision.
to say that you will go on flouting your own orders?
No, my lord, it is
The
not, my lord.
expense of
I
the
was
superior
just beseeching-
authorities.
I was beseeching in order to just give me a day's time. Let me take instruction on this. Come back tomorrow. Kindly keeps it tomorrow. Otherwise, my lord will pass an order.
Better case.
Please come. The petitioner seeks benefit in terms of the document annexed, not terms, in line with the document annexed at page 121, annexure P9 to the writ petition dated 4th April 2024. Stop. Learned advocate for LICI seeks time to revert with instruction. Friday.
Grateful.
For the petitioner. But the petitioner is let us say, was appointed as a driver of of South Bengal State Transport Corporation in the year
SBSTC?
SBSTC, right?
Yes.
In the year 1991. As a driver. Subsequently, in the month of October.
Your prayer. Tell me your prayer only.
Prayer is the appeal was pending.
Disciplinary proceeding initiated against you? Yes.
Subsequently, we have.
What is the punishment?
Punishment was going to kindly come to my page.
Basic pay reduced to 4 stages.
All right.
Period of suspension to be treated as suspension, and short amount. There's a shortfall in his collection bag that is to be recovered from his salary.
All right.
So these are the 3 million.
And you preferred an appeal?
Appeal is pending. It has to be.
It has to be disposed of. This is the order that you are praying.
In the meantime, my lord,
You have retired? All right. When did you retire?
In the year
31st January 2025. And retirement benefits have been paid.
Oh, wait, date of retirement is 31st of January 25. Writ petition was filed in 24. And appeal preferred?
Appeal preferred
Wrong
my
time.
lord,
31st March 2014. It should have been. Kindly direct.
and subsequently, my lord, we have made several representations, several reminders, but nothing has.
You got your retirement dues.
Yes, my lord.
But taking into consideration the order of the disciplinary authority, all right, please come. The petitioner was serving the South Bengal State Transport Corporation. Stop. A disciplinary proceeding was initiated against him and an order of punishment was passed. Stop. Challenging the same, the petitioner preferred an appeal before the appellate authority on 31st of March 2024. Stop. The same is pending disposal till date. Stop. The petitioner has retired on 31st of January 2025. Stop. He has been paid his terminal dues in line with the order passed by the disciplinary authority. Stop. Prayer has been made to direct the authority to dispose of the appeal. Stop. Paragraph. As it appears that the appeal in question is pending disposal before the appellate authority for more than 2 years, and the employee has retired in the meantime, it is high time that the appellate authority considers and disposes of the appeal preferred by the petitioner strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the appeal of the petitioner is allowed, or any order passed by the appellate authority modifying, setting aside or varying the order passed by the disciplinary authority, the necessary consequential steps shall be taken by the authority without any further delay. Disposed.
Obliged.
Next.
This is a transfer brief. I have been instructed to appear. Lordship, I am handicapped to that fact that whether this notice has been served.
All right, none appears for the respondents. Let fresh notice be served. Release turn. Any urgency?
1 week time also in the meter.
4th of May.
Yes.
Next. Has fresh wakalatnama been filed?
Lots of advocate and record has filed.
Filed it? All right. Yes.
Yes. I'm praying before you for a short passover.
On behalf of whom?
Mr. Sushant Topal.
Who is he appearing for?
ECL. He's already on his legs, I've been informed. So just a short passover, Your Lordship.
Let me hear. Call him. Yes.
My lord, this petitioner's father,
Huh.
who was an employee under the Eastern Coalfields Limited,
Huh.
had suffered an unnatural death. Unnatural, my lord, immature death, my lord, in 2017.
Died in harness.
My lord, yes. My lord,
Then?
the family applied for a compassionate appointment for this petitioner. She is the daughter, and my lord, all financial benefits. Now, everything was processed. Even this petitioner was directed to submit, my lord, an indemnity bond with undertaking that she would maintain the other members of the family, and if in future for whatever reason, my lord, her employment is questioned, she would refund everything. Now, when the final stage came, my lord, one lady came and she lodged a complaint that she was the first wife of the legally married wife of this petitioner, of the husband. Now, my lord, she also filed a suit for declaration that she was the first married wife, impleading the husband, this petitioner's father, the mother. Now, kindly, my lord, come to page 32.
Yes, the suit stood abated.
My lord, page 22, page 22.
Huh.
My lord, mother and my elder sister.
Yes.
This was in 1998.
Yes.
Then this petitioner did not born. This was then 23. My lord, this was submitted by the husband himself for release of all financial benefits in favor of my mother.
Hmm.
Now, kindly, my lord, turn to page 32.
Hmm.
What was the fate of the suit?
Yes.
My lord, last two lines. The right to sue in this suit does not survive with other defendants of this suit. So the suit is hereby stands abated. Hence, it is ordered that the instant suit be, and the same is hereby stands abated. There is no suit, there is no dispute surviving. Even then, my lord, my prayer has not been considered.
All right. Yes.
My lord, so far the compassionate appointment is concerned, my lord, it is suffers from delay because, my lord, the husband of the petitioner died in
2017.
and suit was abated so far as per their information that from it appears that
2018.
Yes, and they filed the writ petition on 2025.
What are you doing?
Malad, and apart from this, there is compassionate appointment is not must. There is the alternative provision is there. There is MMCC.
You give MMCC to her? Who's stopping you?
Well, I have to take instruction because today I have only been briefed.
And you raise frivolous objections. The writ petition is filed delayed. There is a chance, there is another opportunity to get employment and MMCC and everything.
Yes,
you should address the court properly, sir. It's not that you only appear for the respondents, you appear for the petitioners also. Suppose somebody standing opposite to you have made this submission, what would have been your reaction to it? The husband of the petitioner was serving. Father of the petitioner was serving the Eastern Coalfields Limited. Stop. He died in harness in the year 2017. Stop. The petitioner applied for compassionate appointment. Stop. The same was processed, but thereafter it could not be finalized as the private respondent raised a claim with regard to the marriage with the father of the petitioner. Stop. A suit was filed by the private respondent seeking declaration of marriage. Stop. The said suit being TS 286/2011 stood abated. Stop. The petitioner submits that ECL has not taken any steps to finally dispose of her prayer, either for compassionate appointment or for grant of monthly monetary cash compensation. Stop paragraph. Learned advocate representing ECL is directed to revert with written instruction. Stop. Released on 27th of April. Let further notice be served upon the private respondent.
Or can it be 28th?
28th.
Fine. Great. Yeah.
9. Dismissed.
Your Lordship, I am for the petitioner. Actually, I could not find the affidavit of service, Your Lordship. Therefore,
All right.
preparing for
None
liberty.
for the respondents. Let notice be served. Released 4th May.
For respondent number 3, 4, and 5, corporation.
For the petitioner.
Sir, I am for
Yes.
the PF authority. May I file my report?
All right.
Copy them.
Xerox করে করতে পাঠিয়েছিল।
Wait, please, Your Lordship. I appear on behalf of the petitions being led by Mrs. Chama Mukherjee in this matter. She is appearing online.
I'm online. Lordship, I have some family medical issues. I'm not in a framework to do matters today. Your Lordship, will kindly take up this matter next week.
Adjournment has been sought for by the learned advocate representing the petitioner. Stuff released 4th May.
My report may be taken up.
Yes, please. Report filed by the
PF authority.
number 6 be taken on record. Did you serve?
Yes, I have served upon the.
All right.
Given to us.
I'll serve.
This
We have
of Lordship.
filed our-
And report by?
SBSTC is already filed, on the previous occasion.
Oh, it was filed on the previous. This is your states. Tuhina Parveen. States report. Report filed by the state. Be also written with the records. It will be open for the petitioner to file exception to the reports prior to the adjourned date. Next.
Thank you. Thank you, sir. Grateful, Lordship.
Today, my lord, because my senior, Mr. Robil Islam, is engaged to appear in this matter, my lord. Today, my lord. My lord.
Engaged?
Yes, my lord. I'm praying for only one day.
No. What is the matter about?
Not I, my lord. Brief.
I'm appearing on behalf of the English Bazaar municipality.
Yes.
The matter is very short, Your Lordship. It relates to an unmarried lady who is working now in Kamarhati municipality.
Kamarhati?
Yes. She is seeking a transfer to English Bazaar municipality from Kamarhati, stating family reasons and her small child, 2.5-year-old child. I would just like to draw Your Lordship's kind attention on page number 23 and 24.
Yes.
Annexure P.
Yes.
Regarding prayer for transfer from Kamarhati municipality to English Bazaar municipality, her prayer dated 9/9/20.
This is what I was wondering. Where is the provision for transfer in the municipality?
This is what.
Call your senior. Pass over.
Well, kindly keep it not today, my lord. Brief is also, my lord, is not.
Brief is not here?
Yes, my lord.
All right, tomorrow.
Is engaged to, my lord.
Tomorrow.
Tomorrow, my lord, not today.
All right. Come ready. How the it will be maintainable.
Yes.
And even if the senior is not there, you will be there. Otherwise, matter will be dismissed.
Grateful, Your Lordship.
Sorry, my lord. My lord, I am for the petitioner.
Who is your learned friend in the other side?
My lord, I have served long back. Your
Long
lordship.
back.
Yes, my lord.
All right. What is your prayer?
My prayer is, my lord, in this matter, my lord, petitioner is appointed as a Anganwadi Shohaika. That is, my lord, helper. Now, in the year 2024, the government issued notification that the Shohaika would be promoted as Kormi.
But these matters were taken up in the group 5 determination. You are there in group 6.
Now, group 6 also, my lord, your lordship can't be taken up.
What is
Last
your
time,
prayer?
your lordship, kindly have a look. The advertisement. That is the government circular.
All right. What is your prayer?
My prayer, my lord, I have, my lord, they have made an advertisement for the eligible candidate. I have made application, but till date, no interview was taken. No interview date has been fixed by the authority.
This was in 24. 2 years have passed.
Yes, my lord. From last 2 years, my lord, no, my lord, despite my lord receiving my application.
All right, please come.
My and other candidates, my lord. No steps have taken for.
In response to a recruitment notice published by the Child Development Project Officer.
Page 18.
On 27th February 2024 for recruitment of Anganwadi Shohaika.
No, this is
for recruitment of Anganwadi Kormi. Not recruitment, it's promotion, isn't it?
Yes, it is promotional post.
Kormi on promotion from the Anganwadi Shohaikas. Petitioner applied. Yes, the petitioner applied for the same.
Yes. Next page, my lord, the
stop. Allegation is that no steps have been taken by the authority in furtherance of the said notice. Stop. Paragraph none represents the respondents. Stop. Let further notice be issued. Ache, who is there? Is anybody there online? Item number 13.
13, my lord. Yes, my lord. Due to network problem, my lord, just video have just let I have
All
been.
right. What is your instruction?
My lord, I am waiting for the instruction, my lord, in this matter. My lord, kindly give some time. I am just praying for accommodation so that the next day
The recruitment process started 2 years back. The writ
Right, my
petition was filed 1 year back. And in 1 year, you did not find time to obtain instruction.
On the next day, my lord, if positively just I am seeking for
You
my lord.
are
Kindly
as
allow
good
me
as
to
the
consider.
respondent authority. Released
My
4th
lord,
of
kindly
May.
Yes,
Written
my lord. Kindly
instruction
consider.
shall be produced on the adjourned date.
My lord.
4th of May. Oh, result of the election. It's a very precious day. So what? You will obtain instruction prior thereto. What has that result got to do with the matters? Then, next.
4th May. And the same.
I'm grateful, my lord. I'm grateful.
Item number 14.
But this is a case of plan for the respondent number 3 in this matter.
Yes.
Relating to compassionate appointment, my lord.
Yes.
The petitioner's father, my lord, met with an accident on 13th of June 2019. He died on the same day. My lord, the application for compassionate appointment was made in 31st of July 2019, within a month's time. Thereafter, my lord, it was being kept pending, my lord. Now there was a direction for filing report. In the report, my lord, the reason which has been stated is that the cadre where the petitioner's father was working, departmental worker in FCI, my lord, that has been declared as a dying cadre by the appropriate authority. That is why they are not giving appointment. Now, my lord, this decision of declaring this as a dying cadre, my lord, is a decision subsequent to the death of the petitioner and the application there too for the compulsion appointment. My lord, if the documents disclosed in the report, my lord.
First, you tell me whether the service condition of your father permits appointment on
Yes,
compassionate
there is a
ground.
scheme for appointment.
There is a scheme. Yes.
My lord, although there was a scheme,
Hmm.
well, in 2020, 2015, well, before the death, there was a judgment of the my lord, Bombay High Court, my lord, division bench. My lord, you'll also kindly see this is the judgment.
Now, what does it say? On which
That-
point?
Point say that this cadre.
Listen,
Huh?
why are you are not required to engage him in that same cadre? You engage him somewhere else.
Well, my lord, the policy decision is the same. We engage to same cadre because it's
If
not a
you
direct.
have a contrary policy decision, that is your problem.
My lord, you'll also this is not a matter of right. My lord, you'll also kindly see I have the judgment.
Absolutely, it's not a matter of right. It is in terms of the scheme that you'll provide appointment to him.
My lord, you also kindly see the judgment first. Then
No, I'll not see the judgment. I'll see the scheme.
Scheme is there, my lord. Scheme you'll also kindly see. Scheme in the report, my lord, I annexed.
Yes, please.
My lord, you'll also kindly come to
Yes, which page?
paragraph 6, page 3.
Yes.
And my lord, paragraph 7, annexure 2 is the scheme.
Hmm.
Paragraph 7, annexure 2 is the same.
Hmm.
Therefore, this is going on. My lord, they
Show me that annexure Act 2.
to page 11, my lord.
Recruitment procedure. Next scheme. This is a scheme. Is this a scheme?
My lord. Even thereafter, this is 2003.
Or this is a recruitment process, appointment of departmental workers. My lord, subject. My lord, that only the next it has been decided that henceforth the principles of ceiling limit 5% of the vacancy earmarked for the direct recruitment quota of the said post. My lord, it is the scheme that 5% of the state's quota has to be
Yes,
filled
yes,
up.
I have followed it.
My lord, thereafter, you'll also kindly see this was going on. My lord, availability of vacancy is there, my lord.
Yes.
Next paragraph, page 12.
Hmm.
Page 12, my lord. The sanction strength of such and such.
Page
syllabus-
13, circular number 3 of 13. And the officer at present compulsion.
The paragraph, first paragraph and the third paragraph, my lord, the 5% of total vacancy quota. Thereafter, my lord, the judgment came not directly with regard to departmental laborers. My lord, the in appeal matter, the court said that the FCI should abolish that post. You also kindly see just that paragraph of the judgment was.
Give him appointment in some other post if you have a scheme.
But some other post, it is a departmental labor.
Where is it mentioned in your scheme that he has to be appointed in that cadre only?
5% of the direct recruitment quota, my lord, that you also kindly see. Vacancy to be paragraph 12.
Yes.
The authority appointing authority will hold a 5% vacancy in the category to fill up as a compulsory appointment. In this category, 5% in this category. My lord, I have a vacancy position, my lord. The
If
vacancy
the
position.
seat limit is 5%, then within 5%.
My lord, 5%, my lord, after my lord, the 2015 judgment says that we abolish that post. So we have written to the, as per the judgment, because there is a detailed judgment has been given, you abolish that post. We have written to the ministry. Ministry has ultimately declared the dying cadre. There is no further recruitment in those cadres.
Where are you recruiting the compassionate appointment recruitees?
In this quota the category we are not recruiting any.
In which quota are you recruiting?
But the other the regular service of the they are who are the dying in harness, we are recruiting that service.
No, I did not follow.
My lord, here, my lord, the circular says, my lord, the of the relevant post.
Yes.
Relevant category. But we have, my lord, the category we don't have any vacancy here now. But I have the
In the live register, you do not maintain a live register
But
for
after the judgment and after it is declared as a dying cadre, we cannot do that, my lord. Now, your lordship, that's why I want to show your lordship the judgment. We cannot do that.
It has now been decided that henceforth the principle of ceiling limit of
There are
5%
there
of
are, my lord,
vacancies for the direct recruitees at entry level post for appointment is as already applicable in case we
now
learn
will
to be
kindly
followed appointment
kindly
down.
paragraph
Limit of 5% quota cannot be increased. So 5% quota is still there for compulsory
5% quota of this post is not there. There is no further recruitment. The post is banned. Now there is a dying cadre now. Let's kindly see the page 15. Page 15. It's the Ministry of Consumer Affairs. Say that please refer to such and such. Mentioned in this regard that department has examined the proposal of FCI regarding declaring the departmental labor as a dying cadre, and the same has been accepted by the honorable minister.
As
Such and such.
examinable
These have been accepted in 2020 after the
No,
Yes,
after 15
regarding-
from 15
1
minutes
minute on the subject the department has examined the proposal declaring the departmental labor.
After the also kindly see next circular, page 16, last paragraph.
Yes.
Accordingly, the matter was examined by FC in the light of the recommendation of the handling and the direction of the Honorable Bombay High Court for phasing out the departmental labor system. After detailed deliberation on certain such meeting held on such, Board of Directors recommended to the Government of India to declare the department as a dying cadre. Necessary approval has now been granted. 6. In view of the aforesaid decision of the Government of India, the departmental labor system tends declared as a dying cadre, and therefore, as field officers are instructed to ensure that there is no further induction in any worker under this system. Wherever in any court case is pending for such induction, appropriate application affidavit shall immediately be filed before the Honorable Court. So, to bring this circular on record along with the
What
supplemental
does this
submission.
departmental labor system mean?
Departmental labor system, departmental labor system
means, what does it mean?
Departmental labor system means the FCI has some godowns. In the godowns has some godowns, food storage godown. In the food storage godown for handling of the food grains, departmental laborers are required. There are 4 types of laborers. One is departmental labor, one is contract labor, one is direct payment system labor. But the departmental labor now, these minimum, those are working. No further recruitment in departmental
All right.
labor.
So you have got the other cadres.
Well, other cadre means the contract labor system. That is the that system means they are working, and whatever they work, they will get the remuneration. Well, contract labor system, there is not the such a department. You also kindly see the latest position of the department.
No, is it your case that FCI is not taking up any recruitments?
Not on this cadre.
Show me the judgment.
You also kindly see this judgment. Or this is, you kindly see first. তোমার দেখাচ্ছি ধরো তুই আমার সঙ্গে একসঙ্গে there are several deliberation. Last paragraph, page 30 is the actual paragraph.
Page
25, paragraph 30 onwards.
Yes.
Or there it is totally with regard to departmental labor judgments.
Show me that this is in respect of the died in harness category.
No, it is total departmental labor category.
Sorry, sir.
Kindly come to paragraph 5, subparagraph 5, page 26.
Yes.
The Government of India shall also take a decision regarding abolition of the system of departmental laborers in a phased manner, or abolishing their service in the other establishment as recommended by the high-level committee. Now, thereafter this judgment, after this judgment, the matter went to the Supreme Court, and Supreme Court has upheld this judgment. Thereafter, the matter moved to the ministry. Ministry has passed a circular declaring that it is a dying cadre. Now, in the next circular, last circular, page 18. Page 18, you'll see kindly come once.
You are trying to Mix-up matters. This is a suo motu pill taken by the court
Yes, my lord.
on
On the functionaries of departmental levels.
On a report published in the newspaper where the departmental loaders were earning rupees 4 lakh rupees per month.
Well, at the time of deciding this case, the Honorable Court has passed certain directions.
So
The
what?
directions are in
This
paragraph
is not
8.
your case that you are not engaging anybody in the Food Corporation of India.
My lord, in departmental labor system, my lord, there are four
Any other
categories.
labor system, you give appointment.
You kindly see there are 3-4 categories of laborers.
Show me the rejection. Is there any rejection?
My lord, they kept it pending, my lord.
My lord,
Thereafter there is-
you kindly see last circular. You should kindly see last circular, page 18.
Yes.
In this matter, in this regard, it is informed the matter relating to compulsion appointment in the next scheme of this is DLS and
Is under examination in the light of the change. May be kept on hold. And from 20 to 26, it's kept on hold for 6 years. This is a matter of compassionate appointment.
My lord,
Please come.
It is kept on hold, my lord. This is there.
How long? For eternity? Either you take away the scheme.
My lord, scheme, my lord, the post is not there, my lord. Where from? You know, so kindly see, I
have followed your submission.
I have got two other
Father
judgments.
of the petitioner.
I have got two other judgments.
Regarding
Judgment
what?
says, well, the compulsory appointment cannot be a matter of right. It is.
This is so very settled that you do not require judgments on that.
Well, I know, my lord, the question of 2015 to 2026. My lord, the person died in 19. Now is to 26. My lord, the question of giving, my lord, the financial support at a is not there now.
Yes.
Not there now. My lord, in this, my lord, we also have no post to give appointment.
All right.
These are the.
I will record all your submission and then
Yes,
pass
your
order.
lordship.
The petitioner's father was serving in the Food Corporation of India. Stop. He died in harness in the year 2019. 2019?
My lord, 19.
Yes. The petitioner immediately applied for appointment on compassionate ground. Stop. No decision was taken by the compassionate ground, relying on the scheme for appointment on compassionate ground. Now, relying on the scheme for such appointment, which was prevailing at that relevant point of time. Next, the prayer of the petitioner not being considered, petitioner, not being considered, he approached this court by filing the instant writ petition. Stop. In your short list of dates, I can see one date, 28th of July 2021, FCI acknowledged a policy for considering compassionate appointments. Where is that policy?
Page 25.
Page 20?
25.
25. This is kept on hold.
My lord.
अच्छा की बोला Stop. From the documents annexed to the writ petition, it appears that communication was made by the Assistant General Manager within bracket IR-L to the Executive Director within bracket Zone FCI on 28th of July 2021, mentioning that the matter of compassionate ground appointment has been examined in consultation with the legal division, and it has been decided that such appointment in respect of DLS labor should be continued to kept on hold, and the compassionate appointment in respect of DPS labor may be considered for appointment as per the existing policy. Tell me, what is DLS and DPS?
DLS means no direct labor system. There is a
And what is DPS?
DPS means departmental labor.
Alright.
There is some pay difference is there.
All right. And the petitioner's father was
Departmental labor.
DPS.
DPS.
And you say it's kept on hold?
Not DPS, not the circular says DPS labor is kept on hold.
No, it says DPS labors may be considered for appointment. DLS is kept on hold.
DLS ছিল না departmental labor. Departmental labor, DLS labor. She was there. No,
DLS.
DLS.
আচ্ছা তারপর and the DPS labor kept on hold. ঠিক আছে. Paragraph. It has been submitted that the petitioner is suffering from acute penury, and the case of the petitioner for compassionate appointment ought to be considered, relying on the scheme which was prevailing on the date of death of the employee and on the date of making appointment. Making application seeking appointment. Stop paragraph. The divisional manager of the Food Corporation of India has filed a report wherein it has been disclosed that wherein certain circulars have been disclosed. Stop. The circular number 5/2003 dated 4th March 2003 mentions about the existing scheme of appointment for the next appointment of, not for, appointment of next of kin and kith of departmental workers under the above mentioned schemes. Have been reviewed, and it has been decided that henceforth the principle of ceiling limit of 5% of vacancies earmarked for the direct recruitment at the entry level post for appointment on compassionate ground under various labor systems as already applicable in case of the employees of the corporation will be followed in case of appointment on compassionate ground in respect of departmental labor system as per the existing schemes. Stop. Next, circular number 3/2013 dated 09/15 April 2013 lays down the procedure for appointment on compassionate ground of the heirs of the departmental workers. Stop. Yes, it mentions that the Board of Directors of FCI, in its meeting held on 18th of March 2013, has authorized CMD FCI to approve such cases of compassionate appointment of the next of kin and kith of the workers who died on work spot, irrespective of the ceiling of 5% of the total vacancies under the direct recruitment quota, subject to the condition that the total number of cases of compassionate appointment should not be allowed to exceed 5% of the total vacancies on all India basis under direct recruitment quota. Stop. The proposal of the director within bracket FC hyphen Roman 3 video communication dated 3rd January 2020 addressed to the executive director within bracket IR hyphen L mentioned that the proposal of FCI regarding declaring the departmental labor as dying cadre has been examined and the same has been accepted by the Honorable Minister within brackets CA, F and PD. Stop. Further circular number 1/2020 dated 8th January 2020 has been placed, wherein it has been mentioned that the departmental labor system stands declared as dying cadre, and therefore all field officers are instructed to ensure that there is no further induction of any worker under this system. Stop. The communication of the Assistant General Manager within bracket IR-L dated 28th of September 2020 addressed to the General Manager within bracket region FCI has been highlighted, wherefrom it appears that request was been made to keep on hold the issue of the matters relating to compassionate ground appointment of deceased DLS and DPS workers till further instructions issued by FCI headquarters. Stop. There is nothing on record after the aforesaid request made on 28th of September 2020. Stop.
Paragraph page 19, there is another circular.
There is another circular. Oh, this has been mentioned by the petitioner only.
This is
আচ্ছা
kept
তাহলে
on
ওই
hold
লাইনটা
departmental
ওই
level
লাইনটা
and
কেটে
this
দিন
is DLS is
লাস্টে যে লাইনটা বললাম there is no further ওটাকে কাটুন ওইটা কেটে দিন ওখানে লিখুন that on 28th July 2021, the Assistant General Manager within bracket IR-L addressed the communication to all the executive directors of the zone, FCI, that the compassionate ground appointment in respect of DPS labor may be considered as per the existing policy. Stop paragraph.
It is mentioned here not DLS is kept on hold. Last
আর ওখানে ওটা continue করুন, and the appointment on compassionate ground in respect of DLS labor should be continued to be kept on hold. Stop paragraph. According to the FCI, the father of the petitioner was a DLS labor, and accordingly, his application seeking compassionate appointment has still been kept on hold. Paragraph. It has been submitted that the matter of compassionate appointment, compassionate appointment cannot be claimed as a matter of right. Stop. Considerable period of time has elapsed from the date of death of the father of the petitioner, and at such delayed point of time, the prayer of the petitioner seeking compassionate appointment cannot be entertained. Anything else?
I have can refer the judgments. Don't require.
This is your contention?
Yes, Your Lordship.
Paragraph.
The Bombay High Court judgment, Your Lordship, can
আচ্ছা,
refer.
ঠিক আছে, Bombay High Court judgment to refer করে দিন। Learned advocate for the petitioner has placed reliance on the
respondent.
sorry, FCI has placed reliance on the judgment delivered by the Honorable High Court of Judicature at Bombay, Nagpur bench in Pill 84 of 2014. Court on its own motion versus Union of India and others. There must be a date. Date 20th of November 2015.
Well, I am referring page 26, paragraph 5.
Wherein the Honorable Court passed order directing the Honorable Court passed order inter alia directing the Government of India to take a decision regarding abolition of the system of departmental laborers in a phased manner, or absorbing their services in other establishments as recommended by the High Level Committee. Next. Prayer has been made to dismiss the writ petition. Upon hearing the submissions made on behalf of both the parties and on perusal of the materials placed before this court, it appears that FCI is placing heavy reliance on the judgment delivered in the public interest litigation by the Honorable Bombay High Court. Stop paragraph. The pill in which the judgment was delivered was in respect of a news item published in the daily newspaper reporting that the depots run by the Food Corporation of India, that in the depots though, in the depots, some of the departmental loaders were earning as much as rupees 4 lakh per month. Stop. The news item reflected abuse of government funds, inefficiency and reluctance on the part of the authorities to act sternly against various persons indulged in siphoning of the government funds. Stop. It was reported that some of the loaders clandestinely engaged services of other persons by paying paltry amount when under the incentive schemes they were getting huge amount of money from the Food Corporation of India. Stop. It was on this report that the court passed a slew of directions. Stop. The bill did not relate at all to appointment on compassionate ground. Stop. The appointment, paragraph, the scheme for compassionate appointment was prevailing on the date of death of the father of the petitioner. Stop. The same was also very much available when the petitioner applied seeking appointment on compassionate ground. Stop. The application was made very promptly, with promptitude. And it is only because the Food Corporation of India kept the same pending for a considerable period of time that the petitioner was compelled to knock the doors of justice by filing the instant writ petition. Stop. The submission of the respondent authority that the writ petition is liable to be dismissed on the ground of delay cannot be accepted, as there was no delay on the part of the petitioner in applying for appointment on compassionate ground. Step. It is the authority, who for who was unable to maintain and manage its internal affairs, that the report of misuse of government fund came to the light, on which the directions were passed in the public interest litigation. Stop. There is no order from any competent forum to not to process applications made seeking appointment on compassionate ground. Stop. For making its own house in order, there is absolutely no requirement of the authority not to process applications seeking appointment on compassionate ground by the heirs of the deceased, who may be in acute financial crisis on the death of the breadwinner. Stop. such applications ought to have been considered in terms of the prevailing scheme. Stop. It is not necessary that the appointments, notice appointment, under the diet and harness category has to be given only in respect of one department or in a particular cadre. Stop. The applicant cannot choose the cadre where appointment can be given on compassionate ground. Stop. The same is the discretion of the employer. Stop. The cadre where the illegal activities were noticed by the authority may have been declared to be a dying cadre and appointment may not be given in the said cadre, comma, na semicolon. The same does not imply that appointment on compassionate ground cannot be considered at all. Stop. As the scheme in question is still prevailing, comma, the authority ought to consider the application made by the heirs of the deceased for being appointed in any other cadre or post. Stop. Delaying consideration of the application on the ground that appointment on compassionate ground has been kept on hold and thereafter take the ground of delay in not processing the application cannot be appreciated. Stop. The authority ought to take a decision whether to allow or to reject the application, relying on the prevailing scheme for providing appointment on compassionate ground. Stop. Next. In view of the above, the instant তার আগে আর একটা line add up করুন. The not the learned advocate for the respondents sought to rely upon decisions on the proposition that appointment on compassionate ground cannot be sought as a matter of right and delay in making application becomes fatal for consideration of application seeking compassionate appointment. Stop. As the aforesaid propositions are very well settled, comma, the court did not rely upon, the court did not feel the requirement of referring to any particular judgment in this regard. Stop. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the ঠিক আছে who will be the appropriate authority to consider the general manager, the divisional manager, the chairman cum managing director.
My lord, it is a decision of the board. Therefore, my lord, would your lordship kindly
chairman cum managing director,
general manager, this respond number 4. you will forward this to the, you will forward this to the authorities.
আচ্ছা ঠিক আছে। Directing the respondent number 4 being the general manager within bracket region to take steps to process the application of the petitioner seeking compassionate appointment and forward the same to the competent authority for taking a decision in the
As
matter
your lordship pleases.
in accordance with this scheme which was prevailing on the day the father of the petitioner expired and the day on which the application seeking appointment was made by the petitioner. Stop decision shall be taken at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop a reasoned order shall be passed and communicated to the petitioner immediately thereafter.
But your lordship, kindly make it 10 weeks because it has to be.
All right, 10 weeks.
10 weeks.
Yes. Oh, there's an application. Please dispose it of. Yes. Sir. Yes, next.
Item 50, I appear for the respondent authorities.
Led by Mr. Jan.
I'm of the petitions in terms of earlier direction. I have been reported that the deficit court fee that has already been filed.
All right.
Now kindly come to page 5 of my writ petition, paragraph 2. Who are the petitioners before Lordship? They are the ex-servicemen or ex-defense personnel. Subsequently, since January 2006, they have been appointed as constable of RPF, Railway Protection Force. Now, what would be their pay fixation? That was initially decided in 2010. If your Lordship turns to page 31, 5th of April 2010, that was the circular prevailing at that point of time. Now, page 33, page 33 cross 3. Lordship got it?
Page number is not matching.
Page number possibly is not matching. Page 33 is some identity card.
I'm sorry, then page.
There are 2 paginations. Check up which one you are referring to.
Page 18, kindly come to page 18 then.
18.
18. 5th of April 2010.
Yes.
Now, I will kindly come to page 20. I believe the clause 3.
All right. Are you seeking pay protection?
No, what I'm saying, apart from the above, it was also clarified under. Now, kindly come to clause 5.
All right.
Fixation of pay of personnel stroke officers who retired prior to so-and-so and who have been re-employed after so-and-so. In the case of so-and-so who had retired prior to and who have been re-employed after that, their pay on re-employment would be fixed by notionally arriving at the revised basic pay at the time of retirement, as if these provisions were made applicable in our case and we were given the benefit.
Yes.
Now, suddenly they came with a plea that there is a wrong pay fixation. It should have been by in another way. And kindly come to page, that's the page 53.
Yes.
It's a order dated 30th of March 2021.
Yes.
Yes. Now, initial fixation of pay of re-employed ex-servicemen who had post below commissioned officer They have decided in another way, and they have asked for, my lord, certain overdraw amount, and that is to be refunded back. In such situation, a writ petition was moved. A writ petition was moved on 20th of November 2023. That was disposed of by this honorable court, holding that in respect of excess payment, if you direct them to refund, we cannot allow the same. Page 80, page 86, my lord, kindly excuse me, because there are double marking, my lord, I am also confused.
Yes, 86.
86, I think it's an order dated 20th of November.
Yes.
I'll kindly come to skip 3 pages, internal
Yes.
page 3, paragraph number 9 and 10.
Yes.
Insofar as refixation of pay scale of the writ petition is concerned, which the railway proposes, the same cannot be subject matter of the instant writ petition. In the event of any refixation contrary to any right of the writ petitioners, they may agitate the same in accordance with law in an independence proceedings. And what's decided here, paragraph 6, that there cannot be any overdrawal or of any excess amount. Paragraph 7, it says, in this circumstance, this court is of the clear and unequivocal view that no excess payment to any of the writ petitioner can be recovered by the railways. Now, regarding pay fixation, that's become an issue. Now, if your lordship turns to once again page 75.
No, ultimately thereafter what happened?
But they are paying us the less.
And the recovery has been stalled.
That has been stalled.
All right.
Let them file a report of what is the basis of this refixation.
All
Once
right.
waiting
And page 86, where you party in this matter.
Yes.
Oh, it was you were there.
Yes, ma'am.
All right. Yes.
Lordship, in this matter, my only submission is that clause 3.5, my lord, which is at page 202, oh my lord. 202, my lord, 2 NT.
Page number?
20, my lord.
20. Yes.
My lord, this is clause 3.5, the fixation of the pay of personnel or of officers who retired prior to 1st January 2006 and who have been re-employed after 1st January 2006. In the case of personnel or officer who have retired prior to 1st January 2006 and who have been re-employed after 1st January 2006, their pay for re-employment will be fixed by notionally arriving at the revised basic pay at the time of retirement. As if, my lord, they have retired under the revised pay structure. My lord, my only submission is that on instruction I am submitting, this clause does not apply to them.
Why?
Because, my lord, by a subsequent circular, this has been clarified that this clause only applies to those who have retired from their prior service as of my lord. My lord, I am
All right, you file a report. Please come.
Lordship.
The matter relates to pay fixation of the petitioners. Stop. According to the petitioners, their pay ought to be fixed in terms of clause 3 within bracket V5, small v, of the OM number 5th OM dated 5th April 2010, annexed at pages 18 to 21 of the writ petition. Stop. The respondents contend that this clause will not be applicable in respect of the petitioners. Stop. Paragraph. The respondents are directed to disclose their stand by filing a report on affidavit. within a period of 6 weeks. Reply, exception if any, may be prepared and circulated within 2 weeks thereafter. Stop liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
Extremely grateful.
Grateful.
I am appearing on behalf of the petitioner, my lord.
Yes.
So this is second round of it.
Are you not appearing in item number 9?
No, I don't know.
Because I dismissed it for default. All right.
It is not mentioned in my list at least.
All right. Item 16, yes.
I know that. I just checked it. If that is, it might be.
Yes.
This is second round of litigation. Petition, my lord. Earlier round of litigation.
I'm for NCC, respondent number 1, 2, 3.
Answering respondent?
Answering respondent. Department.
My lord, we are not the recruiting authority. Recruiting authority is West Bengal Government Higher Education Department.
Higher Education Department?
Yes, but NCC work under Higher Education Department. NCC cadet.
Of the state?
Yes.
Yes, my lord.
All right. All right.
Yes.
My lord, may I place my case? My lord. This is second round of litigation. Earlier round of litigation, my lord, he filed a writ petition for getting compassionate appointment. What happened, my lord? His father engaged in the NCC cadet, my lord. After his mother death, my lord, he married to another woman. That is pleaded in para 3 as well as para 4, my lord. And out of that second wedlock, one son and one daughter was there. I made them as a private respondent in this instant writ petition. And earlier writ petition also he was there. I want my lord compassionate appointment. There is a verbal amicable settlement amongst the family that because they are in distress. Till date, the family not get a single penny regarding pension because our understanding was that, my lord, verbal understanding, what I gathered from them, my lord, from the petitioner itself, my lord. First round of litigation, all about the compassionate appointment. The contempt filed. But the department, my lord, take this case as a pension case, my lord. Kindly turn, I just show, my lord, 4 pages. Kindly turn page number 24.
No, then what happened to your application seeking compassion?
Still pending, my lord. There is no fate.
And who is to consider the NCC or the
NCC, my lord.
No, my lord.
Well, either NCC or department. Either they will decide who will.
My lord, as per NCC Act, we are not the recruiting authority. That is why they have made the party to the answering respondent itself. And my lord, on the earlier occasion also, while the writ was being heard, several submissions were made, and it is in the act itself that we are only working as a receiving department. We are receiving their application and forwarding it to the concerned department.
All right. Did you receive his application?
My lord, the proper the application last we had received, it was mentioned in the earlier writ also. It was not in proper format. That
All
is
right.
why
What is the proper format?
My lord, Higher Education Department is suggesting certain changes, and
where are those documents?
My lord, kindly comes to page number 71.
Yes.
My lord, lastly, they have made the application to the accountant general.
AG Bengal, what will AG Bengal do over here?
Well, kindly turn page number 61.
My lord, it is written their employment on compassionate ground, and they have written that it is not the concerned department.
Kindly
turn page number 61.
Where is your application for compassion appointment? Please show.
My lord, is 61 also it is mentioned.
My lord, kindly turn page number 22. Prayer for employment under compassionate appointment. Thereafter, a reminder, my lord. Kindly turn page number 26, 27, pro forma. 26 onward, page number 27 is pro forma. My lord, kindly turn thereafter page number 61. I made a specific representation before the department itself.
My lord, last time when the
department misled me because until and unless you get the pension copy,
no.
For that reason, my lord, I made the page number 72, which my learned friend.
All right, you forget everything. Show me which is your application.
Page number 27.
It was considered in the last writ, and after the writ was disposed of, only one letter was given. That is in page number 61. Nothing new happened after that writ was disposed of. It was considered in the last writ.
page 26 and 27, these were considered. 28.
Yes, my lord. Kindly comes to page number 61.
All right. Who's for the state? Who's for the state?
I served upon the state. State is yes.
My
And
lord,
none
only
appears
one
on
thing
behalf
happened.
of the state respondents,
This is first.
whose presence is required for the purpose of
Allah.
effective adjudication of the instant writ petition.
For the,
Let further notice be served.
for the state to
Released on
The state and for NCC.
21st of April.
in the earlier order it is mentioned Shayonir
Must be a wrong submission. I'm for Union of India and NCC.
might be.
Yeah.
Then Sumon Basu or
Shumon Basu is.
might be because for respondent number 6.
You give a notice.
Yes,
Right.
as my lord.
Affidavit of service is taken on record.
My lord, my clerk missed it. My junior missed it. Item number 9 is mine, my lord. My junior, my lord. Just
No matter.
yes, my lord.
All right,
They
play.
missed it, my lord. Not in the my lord. Kindly restore it.
Make it not today.
But somehow they missed it, my lord. I'm tender my apology, my lord. Somehow they.
Dismiss for default is recalled.
My junior is a G double O P. For that reason, not came.
Yes.
I will not beg to appear on behalf of the petitioner. This is the third time, my lord.
I'm praying for
Matter-
not today, Lordship. Why? Mr. Joralde is appearing for this. Mr. Joralde is appearing for the state respondent.
Matter
On
is
his
very
legs, your
interesting, my lord. They done a mistake, and by report, when I file the contempt, they file report, they admit that there is a mistake.
What is your prayer in the writ petition?
Lordship, we have challenged the order, page number 26, my lord. That is the report which has been filed.
Where is the learned counsel? On his legs, your Lordship. Let him come. Yes.
Lordship,
Page.
page 26 is the report which has been challenged before the Honorable High Court by filing this writ petition.
Yes.
And my contention, my lord, petitioner is the Asha Kurmi, who has been appointed by issuing letter. And my lord, my prayer that is starting from page number 13, my lord, in the present writ petition. My lord, the report which has been filed, my lord, kindly have a look. The middle portion.
Are you challenging the appointment of somebody else?
No, my lord.
Then what is the
I have
challenge?
challenged the termination first occasion when I come before the Honorable Court. Challenge the first occasion, that is challenge termination of
Your
letter.
engagement.
Lordship.
That was challenged.
That was challenged.
Then
And thereafter, I have given liberty to place
approach the authority.
That has not been done in time. That was I filed.
But thereafter it was given, the hearing was given, and this
when-
is the reasoned order that has been passed. Right?
When I filed a contempt petition, then
All right. Now, what is the error in this order?
error, my lord, as per epic card of Bandana Mandal, that is petitioner, it was noted that she was an elector of part number 49, but her residential village is Shailapur. That is, she is not a resident of Ramnagar village, enclosed R8. And actually, the part number of Ramnagar village was 52 and 54. But
Which
in the
portion are you
notification,
reading? Which portion are you reading?
with 26,
26.
page number 26, which report has been challenged. Before
Clause, which clause?
Lordship, that is the portion, bottom portion of first para.
Page number 26 is the report dated 4th of February 2025.
Lordship.
Right?
In bottom
There
portion
are there are several clauses.
Lordship, I am after 6, my lord.
6.
Para 6.
Yes. Yes.
My lord, they submitting that actually the part number of the Ramnagar village was 54 and 52. But in the notification, it was mistakenly mentioned as 49, which was an inadvertent mistake. The typographical error was done due to the oversight of the authority. My lord, they said that I deeply regret any inconvenience this mistake and may have caused. That is their submission
Stand.
in the my lord, my contention before your honor that due to the mistake committed by their part, what is my fault? I submit all documents, they verify. After verification, they issue the appointment letter. Then all on a sudden they.
Are you a resident of the area where the Asha is engaged?
Lordship, that is page number 46, my lord. Kindly have a look.
Yes.
Actually 47, my lord. That is
Yes.
address Shoilapur, my lord, Kaliachowk.
Where is the Asha engaged? Where is the Asha engaged?
That is, my lord, page number 29 continue to page number 32. That is the notification which has been published by them.
Yes.
32, my lord.
Vacancy was in Akhondobaria sub-center.
Lordship. Ramnagar AC part number.
You were not in Akhondobaria.
Lordship.
Then how can you get the appointment?
But my lord, at the time of verification, they
Tell me whether you are a resident of the area where the Asha is being engaged.
Lordship.
You are not a resident?
Lordship.
What is the error on their part?
Lordship.
They may have made a mistake and it was rectified. Can somebody not rectify a mistake if it is detected?
Lordship, if verification done, if everything statutory which has been done by the authority at the time of verification and
So that there was a mistake which could not be detected. Now it has been detected and steps have been taken. What is
on the
done?
mistake made by their part, my lord.
The petitioner challenges the report prepared by the subdivisional officer Malda Shodor on 4th of February 2025. Annexed as Annexure C to the writ petition. Stop. It has been found that the petitioner is a resident of the village Sahilapur and she is not a resident of the village Ramnagar. Stop. The Asha, not the Asha has been engaged. Asha is required to be engaged in the Akhondobaria sub-center under Akhondobaria Gram Panchayat of sub-center under Akhondobaria Gram Panchayat of Kaliachok -Roman 3. Stop. The requirement of engagement is that Asha has to be a resident of that area. Stop. The authority has found that the petitioner is not the resident of the area where Asha has been engaged. Stop. Paragraph. It appears that due to an inadvertent error in the notification which was published, the engagement was given to the petitioner. Stop. On detection of the error, the same has been rectified and the service of the petitioner stood terminated. Stop. Paragraph. The court, it has been submitted that since the entire matter, since all the documents of the petitioner were verified prior to issuance of the engagement letter, accordingly, at this stage, at this stage, the authority cannot raise the plea of an inadvertent mistake. Stop. Paragraph. The court is of the opinion that the authority ought to rectify the mistake the moment the same comes to the notice of the authority. Stop. It will be highly improper to continue with the mistake despite noticing the same. Stop. Perpetuating the mistake is highly illegal and improper. Stop. In view of the above, the court is not inclined to entertain the writ petition. The writ petition fails and is hereby dismissed.
No, my lord, kindly excuse me. I could not. I was stuck up in court number 11.
Who are you appearing for?
I am for the petitioner with my friend. Now, my lord, if your lordship kindly have a look to the impugned report.
No, it is everything is over. After everything is over, you cannot reopen.
Lordship,
no accommodation was also sought. That senior is engaged. Next.
Lordship, kindly record, my lord, alternative remedy should apply if
it will be open for the petitioner to approach the competent forum in accordance with law in case any further remedy the petitioner seeks?
Deeply obliged.
I'm for the petition. It's a case of compensation and appointment, my lord.
Who is
Not
your
a
other
petition.
side? And where is your other side?
Yesterday he told that they will.
Which
No.
department?
My lord, railway department, my lord.
Railways.
Employee was a staff of RPF department, my lord.
All right.
My lord, initially the petition number 1 is the widow and petition number 2 is the son, my lord. Initially, my lord, the ex-employee submitted an VR, my lord. VRS. My lord, page number 13, my lord. Page number 13. He submitted a VRS and thereafter, and on the ground of that, he was quite ill and I cannot, that is anything will happen in any time that my life is above, I am unable to perform the duty and the voluntary retirement, he is paid, my lord. And thereafter, on 29/4, after 16 days, he has filed and submitted an withdrawal petition, my lord. Withdrawal petition. And the page number 19, my lord. That due to various unavoidable circumstances, myself became frustrated and became dumbfounded what to do. I was completely perplexed and myself applied for my voluntary retirement without adhering the rules and applying voluntary retirement without giving any permissible period. In view of my lord, thereafter, subsequently he was ill and he has died, my lord.
When?
And in the died on the 30th January 2020, my lord.
All right.
My lord, page number 20, my lord.
Hmm.
Annex 3, my lord, P3. Payer for withdrawal, the department has stated, my lord, payer for withdrawal of voluntary retirement application of Sunil Chandra Maji, ex-headquarters. My lord, it has been written to the Sunil Chandra Maji when he was died, my lord, actually. Your application dated, received on 11/6/2020. There was no possibility to apply the same, my lord. He has died in 30th January 2020. And how the application has been made. And not
No,
only
this
that.
date is wrong.
Not only that, my date has been given 3/3/20. He has died in January.
Yes,
Date has been given in March. After the death, it has been intimated that your application above is informed that authority has accepted the VR, has not considered your appeal. There further scope of the entertain of the appeal by the withdrawal.
One minute. Show me your application for resignation. Page 13.
No, withdrawal.
No, your application for resignation. Where is that?
Not resignation, withdrawal. Withdrawal and VRS.
Yes, VRS.
First I have seen 13.
Page 13.
13, my lord. P1. Annexed P1.
Voluntary retirement you sought for.
Yes. And subsequently, within the notice period, as per rule, my lord, within the notice period, anybody can withdraw the.
Yes.
Appeal. That is the rule.
Page 13 is your application for voluntary retirement. Then?
And withdrawal, my lord?
Withdrawal is page number 19. All right.
Yes. The information has been given by the department, my lord. Prayer for in 3/3/20. When after the death. And it is very surprised. Application dated received on 11/6/2020. How he has applied? That is my lord. That is wrong, probably. And initially, my lord, the widow has applied for the settlement dues and the employment of the son, my lord. And initially, erroneously, matter was taken before the Honorable Tribunal, Central Administrative Tribunal. And subsequently, it is found it is wrong, for which it has been withdrawn. And the last order, my lord, page number 33, my lord. Initially, the Honorable Tribunal has passed an order to consider the compensation appointment. And thereafter, it was challenged again. And lastly, my lord, para 3, then seeks permission to withdraw and weigh and liberty to approach the appropriate forum. And thereafter, the instant it has been filed, my lord. But my contention is that it is taken as a normal death, my lord. As because is actually VR was submitted 2019.
When was his date of superannuation?
Superannuation, my lord, page number 8. Page number, my lord. Page number 15, my lord. Annexure 2. Superannuation 30th/4/2024. And
30th.
5 year was due.
Hmm. Yes.
So that is the claim that that should be taken as a normal death, as because the withdrawal of the VR has not been accepted, or it was not known to the
What is the stand of the authority in the report?
authority, my lord. Speaking order, my lord. As per the CAT's order, the speaking order was passed, my lord. Page number 22. Page number 22.
Yes.
No, it is office memorandum. No, it is a. No, it is no. Speaking order, my lord. Page number 27, my lord. 27, my lord.
There is no 27 in the report.
Yes.
There is no page 27.
A speaking order. Speaking order by the department, my lord. At the initial stage, when the
Where is that?
20 annexure P8, my lord.
P8, is it 14th of February 23?
14.
Date?
The page 27, my lord. Speaking order. At page number 29, my lord, in the point 3. 29.
What is the date?
Date, my lord, speaking order date is 15/7/2023. Last, my lord, page number 30.
No, there is no page 30 over here. There are only 25 pages.
20. Huh? Pages. Now, their contention is this, my lord, as the VR has been accepted and the withdrawal has not given any effect, and that once the VR has been accepted, is to be taken as the acceptance, and his return already been made. Naturally, on the death of the employee, the no compensation appointment is to be given. That is their contention, my lord.
And what is your contention?
And my condition, as the VR has been subsequently, it has been withdrawn, and within the notice period, my lord. And
What was the notice period?
Notice period, my lord, 30th/5/2019, my lord.
You applied on the 29th of April 2019. Right? According to the service rule, what is the notice period?
Notice 3 months, my lord.
Where is it? Show me.
There is 3 months. That has been stated, my lord. That is the well settled rule.
Are you aware of the phone number of your learned friend for the adversary? See, it is mentioned at the back of in the back sheet. Kushi Proshon Chatterjee.
Yes, my lord.
Give a phone call to him. I'm passing it over. Call him.
No, my phone number is there, my lord.
You are Khushi Prasad?
No. No, other side. No. This is my
The
petition.
report is there.
Report. Oh. A reply, my lord. Yes. I'm calling you. Yes. I got it in the reply.
You have a copy of the report filed by the respondents?
Yes.
Does it have a back sheet?
Yes. The back side in the first page is there.
The phone number is there?
Yes, madam.
Please call and come back.
Yes. I have this. 19 to 19. I'm for the petitioner.
What is the matter about?
Well, this is a matter about, my lord, non-payment of interest on ex gratia, my lord.
Where were you serving?
Serving, my lord, NVF, my lord. National Voluntary Force.
Yes.
My lord.
When did you retire?
My retire, my lord, 2011, my lord.
All right. And when was the payment made?
Payment, my lord, made on 2019. 2019.
From 11 till 19?
19, my lord.
All right.
My lord.
So you want interest?
No, my lord. So So we just need interest, my lord. That is our prayer, my lord. The civil, well, there are several petitioner, my lord.
Why everybody has come together in one writ petition?
Because all are working in NPF, my lord.
So what?
My lord, I will pay the court fees, my lord.
You will pay the court fees.
Yes, my lord.
When will you pay?
Within a week, my lord.
Within a week?
Within a week or no, within a 4 weeks, my lord.
4 weeks?
2 weeks? 2 weeks, my lord. 2 weeks.
2 weeks?
2 weeks. 2 weeks.
Why? How much is the court fee? Are you aware how much is the court fee?
No, my lord.
No. You should know. How much is the court fee and how much you are required to pay?
My lord, within 1 or 2 weeks, my lord.
3 days.
3 days? 3 days. 3 days. 3 days, my lord.
For paying court fee, how many petitioners are there? Check up.
7, my lord.
No, wait, you don't.
No,
let
7,
him
my
let him make submission. How many petitioners are there?
7, my lord.
Check up.
Eight, my lord. 8.
When you are before the court, it is you who is submitting.
My lord, my lord.
Do not rely upon anything
My
which is said from the side.
No, my lord. My lord.
You have the copy of the petition in front of you.
My lord.
Somebody prompted 7 and you said 7.
No.
You have the copy.
Yes,
You could have checked and you could have
Yes,
mentioned.
absolutely.
How many are there?
8, my lord.
Right. How many court fees have been paid?
100. 1, my lord.
Not 1 or 2. It is only 1.
1, my lord.
Right?
1.
So how many are required to be paid? Balance?
7, my lord.
7.
7.
What is the court fee?
I don't know. 1 on 200, my lord. I hope so.
You have to say how much.
200 and
These are certain things which you should learn.
yes, my lord.
Otherwise, and if nobody teaches you, then it is you who will suffer.
No, my lord.
The client may inquire from you what is the court fees that you've paid.
Yes.
What will you say? You look around?
No, my lord.
Or
That's
somebody
my
will
mistake.
prompt from the side.
No, my mistake, my lord. It's my mistake.
Right? So for payment of deficit court fees in respect of 7 petitioners, how long will you take?
My lord, 3 days, my lord.
Do it by tomorrow. I am posting the matter day after tomorrow.
My lord.
Have you followed?
My lord.
And you will come back and say how much is the court fee.
My lord. My lord.
Released day after tomorrow. Deficit court fee shall be paid in the meantime. Have you brought similar orders passed by this court in this by this bench?
My lord.
It is not annexed over there.
No, my lord. Annexed over there, my lord.
By this bench,
No, my lord. Not by this bench, my lord.
there are orders passed by this bench in these type of matters.
Yes, my lord. Not by this. Passed by Honorable Justice
Next.
Arijit Banerjee, my lord.
Yes. Petitioner? 20, nobody is there for the petitioner. Dismissed. Record your appearance.
Yes. What are these?
Next. Yes.
The petitioner before your lordship, my lord, is a RPF constable. My lord, what happens here, my lord, he was recruited in the RPF, my lord, force back in, my lord, 2019, November. And while, my lord, he entered into the service of RPF, my lord, before that, he sat for the examination of another recruitment by the railway recruitment board for a different vocation. So, my lord, while that particular employment was pending, my lord, he already got himself, my lord, admitted in the RPF employment. So while he was serving, my lord, the result of the recruitment of the previous recruitment process, my lord, came. So there, my lord, he was said to be successful. So, my lord, that was a post of the railway itself of the CC cum TC, which is ticket examination, ticket collectors or something, crew controller and all this. So, my lord, he prayed for the railway authority wanted no objection, my lord, from the RPF authority that he will have to get the NOC, then only you can just come over. So he prayed for the NOC. The NOC was declined. On the ground, no ground was given. Complete just said not permitted. Challenging that, I have come before this honorable court. This honorable court, my lord, observed that since the earlier examination of the RRB, the Railway Recruitment Board, was before, and he previously already enrolled himself in that RRB examination, and thereafter he got himself admitted in the RPF, there is no question of not granting NOC on that particular ground. So accordingly, the order of denying NOC was set aside, and accordingly directed the this honorable court directed the authority to revisit. So after, my lord, the order for reconsideration was passed, the order impugned is passed.
This is under challenge.
Yes, which is under challenge.
Yes. And what is the ground this time?
So they say they, my lord, reiterate that particular part, but that is not a ground. I reiterate that initially you should have mentioned and all this, but finally they say, which is, my lord, your lordship will see at page number, starts from page number 33. So if I just could take your lordship, my lord, page number 35, the last page of the writ petition. So the ground is now that since the post in which right now I am going is carrying the same pay scale, so there is no question of career advancement. So question of giving NOC doesn't arise. So
you require an NOC?
Yes, my lord. I do. If I just could take your lordship, my lord, one page.
You want to join the
railway post only.
Railway post.
Both of them are railways. So RPF is also railway and
the other one is where?
Also railway. So, my lord, kindly sees once page number 27. Lordship's answer will be there at page number 27.
All right, 27.
Page number 27, my lord, the authority in which I am just trying to go, they, my lord, writes to me that you could not find the give the NOC your last time you're giving the time.
To complete your document verification. Cancelled. 23. This has been cancelled possibly.
27, my lord.
Page 27 is dated 23.
Yes.
Right.
Yes.
So this is cancelled by now.
No, my lord. In this meantime, my lord, the order of this honorable court came. So they are also, my lord, party before this honorable court.
All right.
So now, my lord, what happens? The order impugned, my lord, which comes, and there, my lord, this particular point has been taken, which was never a subject matter before the authority, or this is not even a lookout of the authority. That this is my choice where I wanted to go, but if there is any legal bar, if I cannot go in that event, they can say. But if there is no legal bar, they cannot just, my lord, take this point that there is no scope of career advancement, so you don't go. So, my lord, if your lordship kindly sees once, because the order impugnment starts from page number 33.
Yes.
So there your lordship will see there is a timeline given from paragraph number 5, 6, 7. Where, my lord, 7 will your lordship will see that they say that though, if I could please, though he had applied for various railway posts under such and such, prior to joining RPF, the examination of the above post was held on 2021 and 2022, more than 1 year after he joined RPF. So further on perusal of record, it is seen that he was called on verification on such and such, but he applied for NOC only on such and such. He had ample time to inform disclose the competent authority or seek permission. So which ground is already rejected by this honorable court on the earlier round of litigation. Now, my lord, kindly sees further ex-serviceman candidate for availing the ex-serviceman quota records declare that he has not been. This is again the same thing. Now, my lord, kindly sees paragraph number 9, page number 34.
Will you be treated as an ex-serviceman?
But yes, but I am anyways ex-serviceman, and I was I joined in
this job and go to the other job.
I was ex-serviceman. I used to work in army.
Oh,
so
I see.
I got my employment in RPF
all right,
as an ex-service. So, my lord, 9 kindly sees the rule, my lord, they quote NOC is granted to railway employees servant in accordance with section 1401 of the Indian Railway Establishment Manual 1989 and section 24 of the Indian Railway Establishment Code. Forwarding the application to another post in railway service or outside the railway permission to railway servant to submit an application for a post to appear for an examination for a post or to transfer his service to another post in railway service or in another office or department under the government of India or under the state government shall not ordinarily be refused unless the head of the office or department in which he is employed considers that the grant of permission would not be consistent with the interest of public service. 1401. Railway employees may be given 4 opportunities in a year to apply in response to notices of government department, public sector undertaking, autonomous bodies, wholly or substantially financed and controlled by the central or state government, except where holding of any such application is considered justified in public interest by the competent authority. Applications in response to UPSC advertisement will not be counted against the 4 opportunities mentioned above. Note, the authorities should interpret the term public interest strictly, subject to the condition that forwarding of applications should be the rule rather the exception. In taking the decision to withhold the application, the competent authority has to balance the interest of the state against the necessity of causing hardship to the individual. This discretion should be applied with the utmost objectivity and not mechanically. While it is not feasible to lay down the specific exhaustive guidelines for withholding applications, some of them can be listed illustratively as follows. The railway employee is engaged on important time-bound projects and the work would be seriously dislocated if he is relieved. A railway employee is under suspension or is facing departmental proceeding or prosecution in a court. A railway employee is applying for a post which is equivalent in status and rank. The post, now my lord, they say, the post CC cum TC for which Prabhat Ranjan had applied and was selected in equivalence, lordship has seen. Rank and pay grade, which is already serving, there is no career advancement involved. By shifting from one job department to another job department within the railway, with both posts are the same pay scale and grade. And this is the no objection is not granted. So, my lord, the only thing that they could pray is about the illustration, which is, my lord, 14013. So there it is said, my lord, in natural code, lordship has already seen that in public interest strictly, my lord, it has to be seen whether it is opposed to the public interest or not. So there has been an illustration which is close, which says is applying for a post which is equivalent to in status and rank. So, my lord, there, I just beseech your lordship, my lord, here, this railway employee, my lord, this particular provision is applicable only when he is there as an employee of a railway, not an RPF. So, my lord,
not RPF.
Not RPF. I tell your lordship, this railway employee means, my lord, what happens here, in many of the cases in railway, because lordship knows that there are different, my lord, what is called that medical requirement of one particular railway employee is to be there. It's called A1, A2, A3, B1, B2, B3, C1, C2, C3. So some of the cases, my lord, where the employee cannot qualify themselves, my lord, in a appropriate medical category of A1, A2, then he immediately tries to shift in a different medical category, which is C1 to C3. Maybe. So which is of a lower medical category. So there, my lord, he makes the application so that he can just retain his job in the railway. So in that cases, my lord, this particular provision is taken into consideration. So this is only with respect to the railway servant, while, my lord, there have been, my lord, my lord, the recruitment inside the railways itself. So it is not a protection forces employees of the railway, which I was there previously working. So, my lord, my respectful submission before your lordship, that previously when my application was rejected, previous occasion when this application was rejected, which is interfered with this by this honorable court, that reason was definitely not there. Once again, after it has been sent for reconsideration, well, that order has been taken into, that new ground has been taken.
No, the ground right now is your application is in respect of a post which is equivalent in status and rank.
Well, in the railways itself. So while, my lord, I was serving in the RPF, my lord, my rank was completely different. And my status would be, my lord, completely different, because I would have been, my lord, a discipline force employee in that unit, not a railway servant.
All right, this manual, Indian Railway Establishment Manual,
Yes.
Is it applicable to the Railway Protection Force?
My lord, railway IRDM manual, my lord, is applicable exclusively for the railway civil posts. But, my lord, there are provisions. My lord, I must be candid to your lordship. There are provisions like medical category, as I said, that like 543, 544, 545, they are perimeteria provision of the RPF as well. So these are followed in RPF. Some of the provisions are IREM. So otherwise, my lord, this Indian Railway Establishment Manual and Indian
Railway Establishment
and
Code.
another, my lord, it is called
IREC.
Yes, that one. So they are on exclusively for the, my lord, railway service, so
Mm.
not for the RPF. So my lord, my respectful submission before your lordship that this is nothing but imposition of a new ground which was not there in their initial rejection, and this is only for the purpose of, my lord, standing in my way of getting to that employment. And another, my lord, I'll just pray before your lordship one thing, because since my learned senior is representing, my lord, all the authorities, including the authority in which I wanted to go. But could it be, my lord's pleasure, my lord, to seek for the instruction from my learned senior whether they, my lord, what is the position in my employment over there? Because I cannot just, my lord, if I just today
Oh, what do you mean to say your position in employment?
not there, because substantial time has gone now. In this meantime,
You are still there in RPF?
I am there in the RPF only. I'm working.
And you are still interested to join that railway post?
There.
Still interested?
Yes, absolutely. My lord,
What
because
is
this
the reason for your interest?
because, my lord, that would be, my lord, my desk job, not, my lord, RPF, my lord, protection. I cannot right now do this because I am anyways an ex-serviceman. So this is why I wanted to shift my lord, trade. So this is why I appeared for the examination. There was no unlawful thing, my lord, that I have done.
And is the vacancy in which you seek appointment now still there?
This instruction, I was just requesting your lordship, if my learned senior friend comes to your lordship, and
yes,
because that would be, my lord, my prayer before.
We are not representing the railways.
You are not representing the railways. Only the RPF.
My lord, the railway is a respondent, my lord, number.
Who is representing this? Did anybody represent earlier? No, I see your name for the Union of India only. Did anybody represent? No. No appearance was ever made.
Four, your lordship will see. One is the Union of India, the Ministry of Law and Justice.
But then the Union of India also appears on behalf of the railways,
Yes,
isn't
my
it?
lord. One place we need to serve only in Union of India in 11 Stand Road.
Eastern Railway? You can take instruction on behalf of the Eastern Railway.
If your lordship pleases, will direct.
Railway Protection Force is not a party over here.
My lord, respond number 2. My lord, Principal Chief Security Commissioner is a post in the RPF. It is not written. I'm sorry. The respond number 2 is a
You mentioned it
Chief
Eastern Railway.
under because they work under the
Eastern
Eastern
Railway.
Railways.
But then RPF is not mentioned.
It is not mentioned. It is my mistake. It's my mistake.
And
Post is of RPF, but it is not mentioned. My mistake.
I think you can take instruction from the other respondents also. Please come.
Union of India sir দিয়েছি একটা জায়গাতেই তো কপি নাই যেটা Ministry of Law and Justice.
The reasoned order dated 20th February 2025.
You have officers' numbers?
Passed by the IG cum
Officer number?
PCSC
Call करते होंगे ना?
/RPF. Refusing the prayer of the petitioner for grant of NOC for joining the post of commercial cum ticket clerk is impugned in the instant writ petition. Stop. The stand of the Eastern Railway is required to be brought on record for proper adjudication of the list. Stop. Isn't PCIG come PCSC a party over here?
My lord, I tell you.
I don't see.
My lord, the Divisional Security Commissioner, my lord, he is the highest authority of the RPF here.
You don't require the RPF now. Now it is.
My lord, it is the Union of India Eastern Railway. But in that event, my lord, could I just pray for your
1 minute.
lordship?
1 minute.
Sorry, I'm sorry.
Let me understand. This respondent number 4 is also from RPF.
Yes.
This also you've not mentioned.
Yeah, I did not. Yes, my lord.
Chairman RRC.
Yeah, sir.
আচ্ছা কি বললাম বলেন
আমার
তো?
this-
End of the railways, Eastern Railway, as well as the RPF authority will be required for proper adjudication. Let separate report by way of affidavit be prepared by the respondent number 2 and the respondent number 4.
My lord, three.
3.
Three. Because that is the Railway Recruitment Council.
Yes.
My lord, who is, my lord, employing me in the railways?
So 2 doesn't got to
2 and 4, both of them are RPF.
আচ্ছা ঠিক আছে 3 and 4.
Yes.
3 and 4. বললাম is required to be for proper adjudication of the case, তাই তো? হ্যাঁ। And circulated within a period of 4 weeks.
4 weeks is
Exception, if any, may be prepared and circulated by the petitioner within a fortnight thereafter.
Grateful.
Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. The respondent number 3 shall disclose in the report as to whether there is any vacancy where the petitioner can be accommodated in the event the writ petition is allowed.
Grateful.
ঠিক আছে. Anything else that is required to be brought on record by the authority? This vacancy position will
That will
be all right.
And my lord, if I just could pray, my lord, since there was an intervention of the other previous rejection order by this honorable court, but if I just could pray, if there is any vacancy left, if at least one post may be kept vacant till this disposal.
This will
At all
be
it is
too
left.
far-fetched.
If at all it is, my lord, exists.
I understand. Too far-fetched
existed-
because see, it is pending from 2025. It was taken up for consideration on earlier occasions.
My lord,
I do not know where you made this prayer or not.
But,
There is nothing on
the honorable
record.
court wanted, my lord, me to bring the previous writ petition's copy. So which I submitted to my lord senior as well. So my lord, this is why I was just praying, if my lord, at all, if there is any vacancy, if it could be left, my lord, one
You
post.
can ascertain, you can come up with an application seeking interim order.
As your lordship, please. Pray your honor. Grateful. Grateful.
Well, I appear for the Diga Shankarpur Development Authority.
Where is the petitioner? Yes. Why supplementary?
There is certain documents subsequently collected. That's why, my lord, the code granted liberty earlier occasion.
Code allowed.
The point of maintainability was taken up.
The code granted liberty. File the supplementary. Now, my lord, the petitioner was appointed as a Group D staff in the Diga Development Authority in 2001 by virtue of the selection process. Now, my lord, the petitioner has been working since 2001.
Is it against any sanctioned post?
I'm coming.
Tell me yes or no.
My contention against the sanction post.
Was a regular recruitment process initiated when you were appointed?
Yes.
Regular recruitment process.
I have annexed in Salvador.
in the supplementary affidavit? Show me.
Kindly see the page 10.
Yes. This is an RTI information.
That is
Where
what-
is the advertisement pursuant to which you applied?
Kindly see page 11.
Page 11, situations vacant. Yes.
I am for the peon. Now thereafter interview letter was called upon. Next page, page 12.
Yes.
You know what it was called? I was called for the interview. Next one, kindly see the final score sheet.
Yes.
Kindly see serial number 18. Bimal Kumar Patro, 9. Score 9.
Yes.
Now kindly see the next page, page 15. In the below of the page, Sri Bimal Kumar at such and such stood fast in the interview.
Who has prepared this score sheet? Who has signed it? Yes.
Now, Malodi.
Who has prepared the score sheet?
No, I have collected this score sheet.
Where from?
No,
How could you lay your hands upon this score sheet?
Because this score sheet has been produced by my client.
Where from? The court wants to know. Where from could you get this document? Who has signed it? What is the veracity of this document?
But he has collected the document.
Let him collect any document from anywhere. Why will the court look into it?
Because the selection process was done. Even if, my lord, if this score sheet is not been given, but the selection process has been done, interview has been done, I was given appointment. That's why if this score sheet, my lord, is not being annexed, but the fact remains, selection process is done, interview letter was issued, and I was given appointment. And in 2001, I've been given appointment. Now, my lord, kindly see the page 33.
Yes.
Kindly see page 33. Have you also got it?
Yes.
Page 33. But this is the memorandum issued on 25th February 2016. Now, I can see paragraph 3. I am reading that. Now, after careful consideration of the matter, the governor has been pleased to decide to revise the benefit as follows. All contractual or casual or daily rated workers shall continue to be engaged up to the age of 60 years. Engagement of contractual, casual, daily rated workers shall not be terminated except as prescribed in the above referred memo. Consolidated monthly remuneration of the contractual or casual daily rated workers will be as follows. Now, can you see present and revised pay?
You want the benefit of this?
There are certain.
How much are you receiving now?
23,000. 23,000. Now, from time to time, the circle was given. Now, next circular, my lord, can you see 34A? Kindly see 34A. 34A.
35 হবে দাদা, 34 এ লাস্ট পাতা ওইটা দেখাচ্ছ?
The Assistant Secretary, Government of West Bengal issued a letter to the Executive Officer, Diga Development Authority. Kindly the undersigned directive to refer the department's memo dated such and such on the above stated above and to request him to send the required status report or follow up the report regarding the implementation of the. Okay,
Yes, I've followed it. What is your stand?
My lord, I make my respectful submission, my lord, the petition is not maintainable. Because I'll tell your lordship why. If your lordship, my lord, first of all, lordship has seen the prayers, he is praying for enhanced salary as per this memorandum. Now, my lord, kindly, if your lordship takes the writ petition, is not annexed, he is annexed in the supplementary affidavit. Kindly, my lord, takes page 7. This was the first parent memorandum. The others in the writ petition are following this. My lord, kindly takes page 7. Now, my lord, kindly sees the third paragraph.
Yes.
After careful consideration of the matter and in supersession of the aforesaid orders and all other orders issued with the departments in the matter, the undersigned is directed by order of the government to say that casual, daily rate contractual workers, my lord, his base case, he is a contractual worker, who are, my lord, kindly now mark this, remaining attached to various establishments of the government department, director, regional offices for not less than 10 years continuously as on 1st August 2011. That is number one, and have rendered service for at least 240 days each year will be allowed the following benefits. So the two conditions, prima facie. Number one, now sees the paragraph thereafter. The starts with the continuity of service. The continuity of service shall have to be certified by a competent officer not below the rank of assistant secretary in the case of a secretariat department, director in such and such, such and such and such. So, my lord, if these two conditions followed by the certification is not there, he cannot apply. The memoranda which have been annexed in the writ petition are a follow-up. If your lordship takes them, my lord, each is all in following of this 2011. So, my lord, first of all, a contractual employer, lordship will find from the annexures that there was an agreement of 1 year each renewal. So,
Is
my
he
lord,
still there in the Digha development Shankarpura agency?
that I have to take instructions.
Check up whether he's still there. He says he's receiving 23,000 per month.
Yes, এখন কাজ করছে?
Yes, I have annexed this, my lord. I have annexed.
Kindly see page 20 কত রে ভাই এটা 25
Page 54, I have annexed this salary.
25 তো না আরো আগে আছে 20 সবই তো পরপরই তো ডকুমেন্ট yes page 18 these are the this was the agreement on a contractual basis 1 year why
23,870.
23,870 the petitioner is receiving as on 8th of May 2025 at the time of filing the writ petition. That means he is there from 2001 till 2025.
No, but I'll take instruction, but for just for argument's sake, even then this certification has to be there. I cannot certify
Yes,
this.
yes, yes.
I cannot
Certificate has
certify
to
because
be-
your lordships have held that this has to be there.
It has to be there. But I just wanted to know because
yes.
this page 54 is issued by your authority. His engagement is by you.
His engagement is by me. Contractual basis, even before that, there is a document showing that his engagement on contractual basis by me.
Right. And page 54, whether he is on continuous service 240 days in a year, 10 years total, everything, this is the matter of the certificate, but at least something is there to show that he is still on your rolls, payrolls.
Now, this is by us.
Isn't it?
Yes. Page 54. ওই এইটা অ্যামাউন্ট ব্রাঞ্চ ম্যানেজারকে yes this is by us.
Now tell me one thing.
Gotcha.
For giving effect to this memorandum, nobody is required to apply, isn't it? It is applicable in respect of all to whom this is meant for.
Yes, but my lord, I tell you lordship, my lord.
Is there any requirement of
No, I tell you
making a
lordship, not with regard to this case, but my lord, earlier with regard to my lord, matter my lord, concerning Digha Development Authority, my lord, this issue had come up. My lord, it had traveled up to the Honorable Supreme Court. My lord, all the courts held, my lord, this SLB was dismissed, but all the courts held, my lord, that this certification is to be there.
True.
So therefore, my lord, for the certification, possibly, my lord, some documents have to be produced before that, even not an application, but something has to be there so that it has to be certified.
So, assuming he gets hold of this certificate,
Right.
then is he required to apply somewhere? Is there a particular format of application? What is it?
That I think the state দেখে নিচ্ছি My lord, kindly see page 9 of the supplementary affidavit, clause 14. Clause 15, a pro forma statement is hereby annexed. 14 and 15.
A pro forma statement is hereby annexed for supplying information by the respective appointing authority to the administrative department. This is interdepartmental.
That's right.
What is an employee supposed to do to take the benefit of these
I
circulars?
followed it. এটা তুই বলতে পারবি নাকি এটারে?
I can only, my lord, regarding my submission, lordship kindly.
No, I'll take notice of this also.
This, whether they are still working or not, that is to be submitted. to
Correct,
the
correct,
Diga Shankar
correct, correct,
Development
correct,
Authority.
correct.
The certificate is there.
Certificate is there. At least as on that date he was working.
Whatever documents from the subject to
No, মনে হয়
petition
কাজ
have
করছে।
been annexed in the writ petition. My lord, this supplementary affidavit, that statement is made that the petitioner is appointed in a sanctioned post. It was never the case of the writ petitioner in the writ petition. When this preliminary objection was taken at the time of admission of this writ petition, my lord, this supplementary affidavit has been filed. Lordship kindly sees only a clause 10 of this memo. The provision of this order will not be applicable where contractual engagement has been made without any sanctioned post and for any specific project for a very temporary period up to a maximum of 6 years
So
of
let
finishing of the
the
project. So, my lord, whether they are
Shankarpur authority come forward with a report
that whether they are
disclosing
working
whether
in a substantive sanction post, their
was
initial
the-
engagement.
But substantive sanction post is nobody's case, neither the petitioner's case.
Yes.
His case is that I have been
Whether they
appointed as a contractual employee. I have been working since there. This memoranda should apply to me.
No, but then this memo will apply only if he is
yes.
engaged in a sanctioned post.
That is the
Assuming it is not in a sanctioned post,
But I
doesn't get it.
my lordship will not take clause 10 because my lord, whatever order comes to my lordship will have a far-reaching effect in all other cases. Clause 10, my lord, possibly envisages two things. Provision of this order will not be applicable where contractual engagement has been made without any sanction post and for any specific project for a very temporary period. So it has to be satisfy both. So not supposing a condition where it is contractual and not temporary. But I say this was not maintainable, but this clause is both.
You check up and then you come up with a report disclosing your stand as to whether this memo will be applicable to the petitioner or not. You also come up and say,
Yes.
because the finance department is raising all these issues. All right. You can check up with the authority also.
My lord. My lord, let there be a report from the Diga Shankarpur Development Authority. Only then, my lord, subject to correction, my lord.
Again, তুমি
My lord, the issue is only whether they have been engaged in a sanction. Lordship kindly.
The petitioner
Only one thing.
claims to be a contractual employee of the Digha Shankarpur Development Authority. Stop. He seeks benefit in terms of memo number, this one.
There are 3 or 4 memos.
All subsequent.
Enhancing this,
The parent one.
enhancing the amount.
Right. Yes. The memo number ato, dated ato, as updated. Till date. Yes. The Digha Shankarpur Development Authority and the state respondents, particularly the finance department, are directed to file separate reports on affidavit disclosing their stand apropos the prayer of the petitioner. Stop such affidavit shall be made ready and circulated by 15th of May. Exception, if any, may be prepared and circulated by 10th of June. Liberty to mention the matter for hearing on completion of the aforesaid time period. Supplementary affidavit filed by the petitioner in court today be retained with the records. Eta ফেরত দিয়ে দিন।
I'm deeply obliged.
Well, this is compassionate
My lord, I am appealing for the Punjab National Bank led by Ms. Ponara Choudhury. My lord, we have received the copy of the writ petition, but it is without annexures, my lord.
Previous occasion, such plea was made. I personally checked and after that supplied it. I personally checked it and after that supplied it.
My lord, we have not received the writ petition along with the annexures, my
Plea is
lord.
being taken.
My client has already pointed out
A
that
bailed order has been passed on previous occasion.
Sit with your learned senior friend. See which other documents are not there. He'll supply copy. Come back with instructions. All right.
No, one thing, Milan, if she has time today, she is a junior. She come with me. I am after Xerox handing it over to her. From my
Please come. Do I make it only not today?
No, if your lordship wants to hear this matter today.
No, the annexures are not there with her. Give a copy. Let the thing be made in order. Next Monday I keep it. The matter relates to compassionate appointment. ঠিক আছে? Learned advocate representing the bank is directed to revert with proper instruction. Stop. Copy of all annexures to the writ petition be supplied to the learned advocate for the bank by tomorrow.
grateful, my lord.
On which day?
Huh? Monday.
Monday.
13th.
I am for the respondent.
My lord, I am for petition. I am praying for not today, my lord.
Why?
But my learned senior is not well and is not able to come. That's all.
What is the name of your learned senior?
I learned Ashish Bhattacharya, my lord.
This is the claim. He has made a claim for non-payment of the provident fund amount. I have said in my report, the deceased employee has received the entire retirement benefit, including the provident.
And who has come? The heirs?
Yes, has come. Because
a report has been filed.
Report has been filed.
All right.
And he has also filed an exception.
Exception.
He has come with a new story, not the provident fund, in respect of the amount which has been deducted in this from the court cases. Several court cases against the deceased employee. All Lordship aware about this Insolvency Act. So many matters are pending before the small causes court. On that matter, as a guardianship, a direction was made to the court, and you attach the money and pay the money. That money was deposited in the fund. That I have said, but that was not his case in the writ petition. And despite of that, I have disclosed the same.
What was the petitioner your employee or what?
Yes.
Employee.
Yes.
And then the dues were on what account?
All gratuity, provident fund, everything.
No, the garnishee proceeding and all.
Garnishee proceeding was at that when he was an employee, some amount was due and payable. That was that order was passed.
How the amount became due?
Because he has taken loan from somebody
All
else.
right.
I have a court cases, my lord.
All right.
15 court cases against the petitioner. The decree was passed and the decree has to be executed. In execution, the
all those money was paid.
Was directed to attach the money and pay.
All right.
It was done. But he was not aware, perhaps.
Maybe.
Years there.
When did the employee die?
My lord, employee died.
2012, death certificate of Sheikh Manu.
But he retired in 2006. Payment has been made in 2006.
Yes. And writ petition filed in 2025.
It's the old case.
All right.
Somehow I obtained the record.
Yes. When your senior will get well?
It will take time. So
what is he suffering from?
He got dizziness. So
dizziness?
Yes.
Even I am feeling dizzy. Then what is to be done? Only dizziness? Then let him come on Friday. In case he faces a problem, there is an emergency medical unit. He'll be shifted over there.
Okay,
all right?
Okay.
Friday.
Friday. You're right.
Friday.
रे भाई
25 am for the petition.
अरे wait.
Before going the record, my lord.
Yes.
Yes. The matter relates to, my lord, the petitioner was my lord, the daughter of a deceased employee who was my lord, the driver of earlier the CSTC, who died on, my lord, 15th September 1985. Thereafter, my lord, the mother applied for pension. Pension was granted, but she has not received it. In the meantime, she died. Thereafter, the daughter applied. Pension payment order was issued in the year of 2000.
Applied why? She is unmarried?
Unmarried.
All right.
Unmarried.
Hmm.
Unmarried daughter. She was getting. But as he made an application for getting the arrear pension with regard to his mother, the respondent authority issued a notice stopping his, my lord, the pension by saying that you have been granted erroneously. That is why, my lord, the pension was stopped. Page 33, your lordship kindly come. Page 33. Thereafter, series of representation was there that was not considered. That is why prompted this honorable court to grant relief.
Yes, 33.
Now, your lordship kindly come. Page 33.
Is this under challenge?
Yes, ma'am.
Is this under challenge?
Yes, this is
all right. Yes.
Page 33. Have you lordship got it, my lord?
Yes.
Now I am just reading, my lord. A discontinuation of family pension of Chandana Mandal, unmarried daughter of late Bhutanath Mandal, such and such. I am directed to inform you that you are allowed to pension erroneously by the corporation. Your family pension is discontinued with effect from 1st August 2018. You are therefore requested to refund the family pension which was erroneously paid to you up to the month of July 2018. Total amount is such and such. This was challenged. Now the writ petition was entertained. Stay order was granted in respect of the arrear payment. Now, as per the order direction, my lord, the report was submitted. Now, in the report, what is their stand? Stand is
1 minute. Page 33, 5,79,000.
Yes.
Is this the money that you received on account of your pension?
Pension, my
or
pension, my pension.
Not your mother's
No,
arrear.
not mother. As I applied for arrear, that is why it has
This has been issued. And the mother's arrear pension is still due.
Still due.
All right. Yes, then?
Then, my lord, they filed an exception.
They filed a report.
Sorry, my lord, they filed a report.
Yes.
I have also filed an exception to this.
What is the stand in the report?
Yes, stand in the report is, before that, your lordship kindly see the rule. They have, my lord, the banked upon some the statutory provision. Just
I have a copy. I have a copy.
Because on the last occasion.
Yes.
Their stand is that the employee concerned has not, my lord, filed the option for getting the pension. This is their stand. Only this is stand. Now, your lordship kindly see. First, the transport regulation, CSTC regulation of 90. First, my lord, it was published on 22nd April 1991. Before that, my lord, the writ petitioner father has died. The date of death, your lordship kindly, my lord, note.
Prior to 1991, the father died.
No, father died on 15th September 1985.
Oh.
Long before that.
All right.
15th
15th September 85.
85.
Yes.
Now, this regulation, Calcutta Transport Employees Death Cum Retirement Benefit Regulation 90, it was gazetted on 22nd April 1991. Now, your lordship kindly come. Now, rule, my regulation 2, that is very, my lord, the vital thing. death cum retirement benefits are admissible to the employees who were on payroll on the corporation as on 1st April 1984. I am pausing here for a moment, madam. Who were on payroll as on 1st April 1984. My father was within that date.
Did he die in harness?
Died in harness, yes.
All right.
Yes, he died. Thereafter, who are on payroll and remain on the payroll of the corporation till the date of actual notification of this regulation of the official gazette of the government in lieu of the benefit of contributory provident fund. There are two classes: who are on payroll, who were on payroll, and who are on payroll. Actually, they are mixing this. Your Lordship, kindly, again I am reading it. Death cum retirement benefit are admissible to the employees who were on payroll on the corporation as on 1st April 1984. My father died in the year of 1985. He was very well in the payroll. And next one is who are on payroll or remain, or that is subsequent that. And this is available in lieu of CPF, contributory provident fund, in lieu of the benefit of the contributory provident fund. This is the, my lord, with regard to the entitlement. Now
So
you
you say you are entitled?
Yes.
Is it your case that you are entitled?
Yes, because I was on payroll as on 1st April 1984.
And then it comes
thereafter.
And
This is another.
No, why another?
Who are on payroll and
It doesn't say or, it says and. Means it is both.
Now I will, but thereafter I will see, your lordship.
All right.
Why this thing is there? I will see. Admittedly, I was on payroll or as on 1984.
And admittedly, you died prior to this being gazetted.
Prior being gazetted.
Yes.
Now, your lordship, kindly come. Now, your lordship, kindly come. Rule 6.
Yes.
Yes. This provides, my lord, with regard to the exercising of option. 1. The employee who may
No, I won't go to 6. You are satisfied you are entitled in 2. Then only I'll go to 6.
Yes. Now, your lordship, kindly come regulation 40.
40?
Yes. Now, before that, your lordship, kindly come regulation 7.
Yes.
Regulation 7.5, family.
No. First, you satisfy the court that this DCRB regulation will apply to you.
Yes. Your lordship, kindly come state kindly come 40. Rule 40. Rule 40. 40. Family pension. Chapter 7.
No, sir. Please show that this rule is applicable to you. Then you come to family and family pension. I am not satisfied by reading these 4 lines that you can be covered under this DCRB. What I read,
Yes.
I say so that you can make me understand
Yes.
where I am going wrong. This benefit, see,
Yes.
admissible to the employees who were on the payroll.
Yes.
April 1984.
Yes.
You were there.
Yes.
And who are on payroll, which means that the employee had to be in service prior to 1st April 1984 and should remain in service on the day it is gazetted. You satisfy the first clause and not the second. Why will this rule be applicable to you? Is this the stand of the CSTC?
I'm deeply obliged, your lordship. May I just
Yes.
I'm not going into rule 2 because I would have made the same submission.
Hmm.
Not apropos that,
Hmm.
but kindly once takes the trouble to come to rule 6, this will be possibly absolutely clear. Kindly see rule 6 now. Apropos this,
Hmm.
rule 6.1, The employee who may prefer to come under the purview of this regulation, Judge Sahib rakhe hain, shall have to exercise their options within 6 months.
Yes.
Now, my lord, kindly says 2. The employee who were, so rule 6, sub rule 2, my lord. The employees who were.
No, wait. Rule 6, sub rule 2, yes.
The employees who were
Uh-huh.
on the payroll of the corporation as on the date on which these regulations came into effect and onwards, but retired on subsequent dates, but before the publication of these regulations. Exactly the case here. May exercise their options within 6 months from the date of publication of the regulations, provided the refunds are such as. I'm not pausing here for a moment. The petitioner's father was on the payroll as on the date of the retrospective effect of this. But in that case, he had to exercise options within 6 months from the date of that notional thing, because, not kindly sees.
But then the employee has expired. So why will this question come?
No, I'll tell you, Lordship. The employees who, employees who were on the payroll of the corporation date of these regulations came into effect. Her father was there on the payroll. And onwards, but retired on subsequent dates before the publication of the regulations. Then in that case, to come within these, his father had to, my lord, apply within 6 months from this. He has not.
Before that, he had died.
This is a question of retire. His father died in hand.
But now sees clause 3 and 4 for the death.
Yes.
Kindly sees clause 4. If any employee expires before exercising option as referred to 6, 1 and 2, it should be taken as yet not exercised option in favor.
Yes. So there is no question.
No question of applicability. Either way, it doesn't apply.
How do you overcome this hurdle?
Your Lordship, kindly see. Your Lordship, kindly see. My Lord, the rule 4.
That is why, my lord, the pension in favor of the deceased mother, her mother was not given. It was wrongly sanctioned in favor of the petitioner. Then
mother was never given.
Mother was not given. That is the case in the petition.
Pension payment order is issued.
But then
in the meantime, he died.
Because it doesn't apply. No, it doesn't apply. Option was not exercised, not given. It was erroneously given in favor of the petitioner. That is why the impugned order, my lord, notice has come.
Yes.
No, Your Lordship, kindly. The rule 6 provides, my lord, with regard to the exercise of option. Your Lordship, kindly see.
I will not go beyond rule 2. You satisfy 2, overcome 2, then go to 6.
My lord, then Your Lordship, kindly see. Again, my lord, I am trying to, my lord, clear it. It come written. This, my lord, the regulation which has been, my lord, initiated in the year of 1990, gazetted April 19. Death ka retirement benefit, earlier that was not there. In the year of 1990, it has been promulgated. Death cum retirement benefit are admissible to the employees who were on payroll as on 84, and who are on payroll subsequently. I was also there because I died.
Payroll and remain on the payroll.
Yes.
You were not on the payroll till the date of actual notification. How do you overcome? Sorry, please come.
No, my lord. I think, my lord, I am not clear to your lordship. Your lordship, kindly. My lord, your lordship, kindly come the page rule 40. Your lordship, kindly. Rule 40, family pension. Family pension is admissible to the member of the family of an employee who has rendered at least 3 years service, who dies while in service. The benefit shall also be admissible in case of death of the employee after retirement. It is not after retirement. After retirement, it is not applicable. Number 141.
How are you covered? Sorry, sir. Please come.
My lord, may I pray one thing, my lord?
Yes.
Your lordship, kindly give me 1 day's time.
Yes.
1 day's time.
Very well. The petitioner.
Let it be on Friday, my lord.
All right.
I will try to.
The petitioner.
Friday, then
is the petitioner claims to be the unmarried daughter of a deceased employee of CSTC. Stop. She is aggrieved as the authority has she is aggrieved by the direction of the authority to refund family pension. To the tune of rupees 5,79,051,
মামলা কোর্টে চার্জ শেষ হয়ে গেছে তোমার তোমার কাছে
which was paid to her erroneously.
মানে ওর রিপিটিশন ওর কাছে
The data দিয়ে দিন তো ওটা communication video communication page 33.
করছে মানে স্যার ওর চার্জ হন
Learned advocate for the petitioner refers to the Calcutta State Transport Corporation employees. Apostrophe is there. Death cum retirement benefit regulations 1990. And submits that she will be covered by the said regulation and would be entitled to family pension in terms of the said regulation. Stop paragraph. According to CSTC, the petitioner will not be covered by the subject regulation. Yes, regulations. To allow the learned advocate, now on the prayer of the learned advocate representing the petitioner to revert with further necessary instruction. Friday?
Friday.
10th.
Let it be on 16th. It will be better. 16th or 17th?
17th.
Yes.
Next.
Yes.
Yes. My lord, item number 18 or Kosi person was available, my lord. Is
Where is
10
he?
times I want tomorrow.
All right, not today. এটা কত নম্বর ছিল এটা not today করে দিন
26.
Joseph beginning.
Item 26, I am for the petition. My lord, the petitioner before my lord was a candidate for recruitment of constables in the Central Armed Forces. In response to advertisement published in 2024, he applied. He qualified in the written test. He qualified in the physical measurement test and also qualified in the physical endurance test, and also he was successful in medical test. Thereafter, he was called for document verification. He belonged to economically weaker section, and a certificate to that effect was issued by the district authorities of Nodia in the district where he permanently resides. At the time, and the economical weaker a candidate belonging to economical weaker section is treated as reserved category. But his such certificate was not accepted by the authorities at the time of verification of documents, and he was treated as unreserved category. And in the unreserved category, he could not find place in the merit list. But his score is 76% of marks, and the reserved category candidates who found place in the merit list secured 42% marks. And my grievance is against the action of the authorities in not treating me
as a reserved category candidate. Now, what is the stand taken in the report?
Yes, Malad, in the report, firstly, I am submitting the report. In my report is vague, and the report is not in conformity with the direction given by the Honorable Mr. Justice Anuruddha Rai. And the first point they took at the time of admission of the time motion of this writ petition, that it is not maintainable, and it is not maintainable. And in the report, the
Show me your reservation certificate.
Yes, my lord. That is at page 80.
Right, that is dated 3rd of January 2024.
Yes. Yes.
And the last date of application was 31st of December 2023.
Yes.
Why will this certificate be taken into consideration?
Yes, madam, kindly see. Page 82.
82.
Page 83. Similar certificate was issued to another candidate by the same authority. That was acted upon. That is page 83. And
This
he was
is-
treated as belonging to reserve category. 83.
So you want negative equality. You say you are not entitled because you do not have a certificate which was issued within the prescribed period.
Yes.
Now you want negative equality because somebody else has been given relying on a certificate.
My lord, the authorities, they issue certificate in this form and in this fashion.
That is not the lookout of the CAPF authority.
Yes.
Right? There is a timeline within which a certificate is to be relied upon. You have failed to produce any certificate within the prescribed timeline. Right?
Yes, I'm coming, my
So
lord.
the only thing that the court has to ascertain right now is whether the page 83 has been relied upon by the authority for the purpose of providing appointment.
Yes.
This is the only thing.
And my lord, in the report, they have not denied and they have not stated the reason why my certificate has been not acted upon.
I can see the reason mentioned.
Pardon?
Page 6 of the report, paragraph number 4. It is mentioned.
No, in the report, they have not mentioned.
I am seeing it from their report, sir. I am not seeing any document from outside.
Lordship, kindly see what they have stated in their report.
It says that the last date for the online application is 31st of December 23. You have failed to produce any
Yes,
document.
madam, kindly see page 7 of the report. Paragraph Roman 4.
Yes.
The DB is conducted by the concerned CAPFS and hence during DB division, modification, correction, if any is made by the concerned CAPF and as such the commission has no role in DB. That's the document verification. The reason for considering the petitioner under UR category during the DB are not available with the SSC.
First, you satisfy me.
In the present matter, the respondent number 3 is not
All right.
the
First, you satisfy that you have produced a certificate within the due date. Nothing.
No, my lord, ma'am. After the advertisement was published, I applied to the authorities to issue necessary
The
certificate.
petitioner applied for appointment in regular paragraph 2024.
There is a
yes, please.
there
In
is a
the
specific clause
WS
that you have to
category.
possess that certificate before the crucial date.
What about giving appointment to somebody else relying upon the
In that
certificate?
case, my respectful submission, my lord, his certificate was rejected by the border security force.
Yes,
And he
thank
has
you.
not paid the border security force party, my lord.
No, my lord.
That is the problem.
No.
If he wants to know, let him add it border security.
Border certificate, border
As per
security
the
force has no role.
recruitment notice, for the purpose of obtaining the benefit of reservation, a certificate from the competent authority issued prior to the closing date of receipt of the online application will be relied upon. Stop. Next. The reservation certificate relied upon by the petitioner annexed at page 80 of the writ petition is dated 3rd of January 2024, which is beyond the closing date of receipt of the online application. paragraph. Submission of the learned advocate for the petitioner is that similar certificates issued by the competent authority beyond the last date of receiving the online application has been accepted by the authority. Stop paragraph. Who are you representing?
I am for the
Staff Selection Commission?
yes. Union been a staff selection commission.
Then you are the answering respondent. It is you who have you are conducting the recruitment process.
Yes,
No, the rejection was made. There are two parts, my lord. First part is under the staff selection commission for computerized examination. Thereafter, it's sent to the CAPF. CAP assigned to the border security force. At paragraph 7, page 7, he has categorically stated in paragraph the petitioner furthers the DV, that is the document valuation, RCT board, BSF Nodia Center, BN, BSF Kolani did not accept that. But BSF has not been made party.
yes, my lord, that authority is a delegate of the commission.
All right. BSF has not accepted. I understand his date of the certificate is beyond. But what about this? Page 83.
Yes.
लिखूं तो?
Yes, Malad. In that case, Maladi, in that case, BSF has to submit a report. Whether they have accepted or not, we have no information. We have no instruction. BSF party group.
আচ্ছা ঠিক আছে রাইট এবার আপনি লিখুন যে the petitioner seeks now the petitioner alleges discrimination and seeks similar treatment as has been done in respect of other similarly placed candidates whose reservation certificate issued beyond the cutoff date has been accepted. Stop paragraph. As the issue of accepting reservation certificates beyond the cutoff date has not been addressed in the report filed by the Deputy Director of the Staff Selection Commission. Accordingly, the court is not in a position to decide the same. Paragraph. In view of the above,
also I have given the name
the
to
instant writ petition
other
stands
candidates.
disposed of with the observation that it will be open for the petitioner to approach the competent authority of the border security force who allegedly accepted reservation certificates for providing appointment to candidates. Reservation certificates issued beyond the cutoff date for providing appointment to the candidates. Step. In the event any such representation is made, the same shall be considered by the authority strictly in line with the recruitment notice. Step. A reasoned order shall be passed and communicated to the petitioner. Notice within a period of 8 weeks from the date of filing the representation. Arekta jinish, it will be open for the petitioner to file representation within a week from date.
What I am submitting,
yes,
my lord has been pleased to direct the border security force authority. What I am submitting, the team of the border security force at the time of recruitment acted as delegate of the service commission. Their function is over. So, my lord, the authority is the service commission and also the Director General of CRPF. So I am paying, Lordship, kindly direct them.
The BSF and the CRPF are different.
No, yes, madam, because my lord, the officer of the BSF, he was a delegate of the Service Commission.
The recruitment is conducted by the Staff Selection Commission,
Yes.
and there are various CAPF authorities, right? Then the Assam Rifles and everybody are there. They are all separate.
Madam, what I have been able to understand, for document verification and
You
for
are
physical-
called at BSF. This is what you have averred in the writ petition, that the BSF authority has rejected your prayer.
Yes.
Right? So, and accepted also by the BSF authority.
No.
Who accepted? Page 83 was accepted by whom?
By the School Service Commission.
Not school,
No,
the Staff Selection Commission.
Madam, the authority which rejected my certificate did not consider the certificate which I have annexed at page 83.
Why will that authority consider somebody else's certificate?
Yes.
Why will that authority consider?
Madam, authority as the delegate of the commission. Well, that is my instruction.
No. কি বললাম ওই BSF authority. Yes. Consider reason order to be passed. In the event any error is detected, for providing the benefit of reservation to the petitioner, the same shall be rectified without any further delay. ঠিক আছে? Writ petition stands disposed.
Same order may be passed in respect of the next matter.
I'll see the date. The date of the certificate is different.
Yes.
Or is it the same? দেখি?
Same.
Certificate dated?
P1 2020.
Same date.
Same date. 3rd January 24.
That is also 3rd January 2024.
All right. Same order.
Sir, I appear for the respondents.
Well, I am for the petitioner. My lord, on earlier occasion it was heard and directed to the respondent authority to serve the report, but still I did not receive, my lord.
My lord, here, my lord, the report, my lord, has been prepared, my lord, but it is yet to be affirmed because, my lord, the authority, my lord, who will affirm this report, my lord, he is in election training on election duty, so has not come to High Court to, my lord, affirm this affidavit, my lord. So 1 week, my lord, I seek, my lord.
Why don't you give him an advance copy and the affirmed copy you file it on the next day so that he gets to know what is there.
That I will do that, my lord, because I have to arrange in the format. They have sent me, my lord, I will arrange.
That means you have not prepared it. Please come. The affidavit, not affidavit, the report which was directed. And moreover, the report, there is no direction for filing it by way of an affidavit. It's only a report. The report that was directed to be prepared and circulated. Video order dated 9th March 2026 has not been prepared till date. Stop. The authority ought to appreciate that.
My lord, it has been received.
The petitioner is a widow of an employee and she prays for releasing the terminal dues.
My lord, here are, my lord, there are two wives, my lord. There are
The-
two wives, both are claiming.
Whatever is your stand,
My lord.
please disclose by way of a report, and that is the reason this direction was given.
That is here, may I, my lord?
Then rely on it. Hand over a copy to him.
My lord, there are some, my lord, the spelling mistake, etc.
That's up to you.
My lord, that's why
Ki
I am
bolla?
seeking 1 week time, my lord.
Authority should have appreciated, huh? And ought not to have delayed in preparing the report. Stop. On the prayer of the learned advocate for the Union of India, comma, time to prepare and circulate the report stands extended till 17th of April. Release the matter on 24th April. What is this scan? Acha. What is the can for? Can for? Dispose it of. Yes.
29 for the petition, appellate. My
Lordship,
no, this is the 29. On the last occasion, my lord, I had only prayed before your lordship to direct the respondents to consider my prayer. Your lordship had directed me to find out as to why such order has to be passed for reconsideration or national justice has to be abided by. My only prayer, my lord, why I say so, because if your lordship kindly takes my supplementary affidavit, which I was relying on the other earlier date.
Yes.
My lord, if your lordship kindly sees serial number 20.
Page
11, 10 and 11 are of the same year, but of two collieries. One is Sodhpur and one is the headquarters. If your lordship sees the serial number 20, regulated by the competent authority on such and such date. The only reason why I'm saying so, because there is no reasons assigned as to why my prayer has been rejected. Now, if your lordship kindly takes up page 9, this is the mode and modalities by which prior datings are assigned. It is first the appraisal by me, thereafter it goes to the accepting authority, reporting authority, and final appraisal by the CMD. Now, when I apply within time, I had applied within time 15 days. That is there mentioned that how an employee has to fill up the form and do that. But there is no averment or no forthcoming from them as to within which period they are going to decide my case.
Outer limit for taking a decision is not there.
Yes. Now, there's a declaration that within 15 days from my circulation, when I am filling up the form within 15 days, if I am agreed by any reporting authority or the accepting authority, I have to apply for appeal within 15 days. Now, if your lordship kindly sees, the date has been mentioned 38/2023 is the last date where I have to fill up. Now, appeal submission date, the next page, page 10. I have submitted within time, and they reject my application on 19th of December 2023 by a one-liner. There is no reasons aside, and for which matter I'm only praying before lordship kindly directs them to reconsider my application by passing a reasoned order. Even if not an opportunity of hearing is granted, at least pass a reasoned order, because this is an Article 12 authority. They are duty bound to provide me reasons as to why I am not being given the prior dating or the reasons therefore. My representation is with them, as well as my representation is at page.
Yes, so stand has changed substantially from the last days here
Yes,
to today.
because I had done a little bit homework.
What is your stand today?
Your Lordship, the outer limit that my learned seniors mentioned, for that they take out on the online portal. As far as I know, they give the dates by which
They will
the Coal India and the ECL on their online portal. They submit that this is the final date by which, and everything is on online, and they have access to the online, and they are supposed to be checking the online portal for the final outcome. And what is the procedure for the appeal as how the order would be passed within that, whether that timeline is given or not. I'll have to take instructions on that, because I had also mailed my learned friend what documents he is going to rely. If he could give me an advance copy, I could appraise this honorable court with those relevant documents and take instructions on
No,
that.
he's not relying on any new
Your
document.
Lordship. Yeah?
He's
New submission.
submitted that it has been disposed of without giving any reasons. Reasons, one liner. It has to be a reasoned one. Whether you write a essay or you write a paragraph or a précis, it's up to you. Now you have to show first. And second, whether there is a timeline within which the appeal is to be considered and disposed. All right.
May I rely a judgment on it? On the next occasion.
No, is it regarding pride rating?
Yes, it is not regarding with pride rating, but API.
That is the
APR
annual
yes,
appraisal, and that is different. That is
but
different.
the ratio is similar.
Oh, then that's all right.
Paragraph 71. Because this is only related to career advancement and promotion.
This one?
Yes,
pride.
Yes, pride. Pride, APR, all are related to.
No, APR is different. This is
with related to career advancement and promotion.
Career advancement.
Yes.
What is the career advancement you'll
I'll
get?
be promoted to a different category, because this is my last promotion that I would be getting.
Your Lordship, but the writ petition that he has filed, even his prayer that he is making, Your Lordship, though now he has made an amendment application, he is asking prayer A, page 21. He asked for a period for rating to be changed from 2017.
And for which I have filed an application.
That has already been taken
Considered and disposed of, dismissing my claim.
18 and 22, wherein 24, where he has pleaded, he's saying my pride ratings are less because my previous pride ratings were less. So that is a settled provision, and he's not preferred a SLP from the division bench order. So 2017 till 2020, whatever pride rating was there was delay on his part, and that has a concurrent effect on the
subsequent ratings.
Subsequent ratings as well. So in his own submissions, in his own pleadings in para 24.
All right, today you've got to know his stand. Changed stance. You also come prepared.
But if I take a clue from the division bench judgment, the division bench said that my prayer cannot be allowed because I did not prefer my appeal within time. And relying on the division bench judgment, which I was about to place, my lord, that the division bench of our court of Malad already also said that if I would have preferred that appeal, that would have considered in due course and in accordance with law. So I have nothing to say on that. When I am at fault, Malad, I cannot blame others. But when I am doing my duty on time, Malad, they are duty bound also. Malad, in a lighter way, Malad, in a corporate world.
Provided there is an outer timeline, statutory outer time within which it is to be considered. This is number one. And regarding the
reason order,
further grounds to be mentioned at the time of dismissal in an appeal,
my lord,
how much this is to be done,
my lord,
right?
But in a lighter way, my lord, in a corporate world, everything is important other than promotion. But if your lordship kindly sees these type of matters, pride ratings in Coal India, they have a parameters which has to be set out. There are KPI index, there are different type of index that is considered. But in any of the orders which they take into consideration while passing the decision, none of them take the consideration of it.
Please come.
And that is why I only prayed for reconsideration.
Today, now the stand taken by the petitioner on the earlier day has substantially changed today. Presently, the submission of the petitioner is that the order passed by the appellate authority is an unreasoned one-line one. Prayer has been made to direct the authority to provide the reasons for not allowing his appeal. Second paragraph D. Further point urged today is that though there is a specified timeline within which an appeal is to be preferred, there is no outer timeline within which the appeal is to be considered and disposed of by the authority. Step. Submission is that the authority ought to act within a specified timeline as the fate of the petitioner's promotion and subsequent career advancement highly depends upon the pride ratings, which has been challenged by the petitioner before the appellate authority. Step. To allow the learned advocate for Coal India Limited to revert with instruction.
Time.
Release 21st.
Grateful.
It could be 22nd.
22nd.
Grateful. Thank you.
এটাতে কেন কিসের জন্য আছে?
Lordship, being led by Mrs. Chama Mukherjee in this matter, she is indisposed, Lordship. Kindly grants and accommodation will come back.
When? Accommodation has been sought for on behalf of the learned senior counsel representing the petitioner. Step. Next. On such prayer, released on 4th May. Are the respondents represented?
Lordship.
Everybody is there?
The respondent number 2, my lord, I am for.
Give your appearances,
For the
please.
state.
I am for the state.
Wait, lord.
No, we are 2.
No, 4.
We are 1, 2, and 3.
4.
You are 4.
Give you. Have you written it down properly? দেখুন 4 নম্বরের না 2 নম্বর কি দিয়েছে? 2 কেটে দিয়েছে? বলুন।
My lord, on the last occasion, your lordship had directed me to seek instructions and clarifications because my learned senior friends had pointed out that the petition that I had relied upon a similar an order passed by the coordinate bench of this honorable court, where notice was issued, and this was in writ petition number 20340. My learned friend had pointed out that the same petitioner in 20340 had also preferred another writ petition, which was dismissed, and an appeal was preferred, and which is pending for dispose. And I'm very glad that my learned friends pointed that out, and my lord had directed me to seek instructions. My lord, these 2 writ petitions have looked at the orders, all 3 orders, 20340, 57, which is pending, 5751, which was dismissed, and the mandamus appeal, that is 615. I've made a comparison note. I will just summarize what is there, my lord. These 2 writ petitions, that is 24340 and 5751, are entirely different in nature, my lord. In summation, in 5751, the petitioner's request is the same petitioner in those both. The petitioner's request for deputation was rejected, and he preferred an appeal. Whereas in 20340, as well as in my present writ petition, the recruitment notification dated 10/7/24, which I've annexed, is under challenge. My lord, if my lord, I will take my lord through the last part of the mandamus appeal. This is, my lord, page 3. The records reveal, my lord, page 3. Oh, my lord, my apologies. This is the
Which order?
this is the mandamus appeal which you had preferred.
Which writ petition? There are so many.
There is only one. No, there are not so many. There is only one mandamus appeal, and that is mandamus appeal number 615, which you had placed before the honorable court on the last day. In 615, my lord, page 3, in this order, records reveal.
Yes.
records reveal that in the same selection process, the appellant also applied for promotion, and as his claim was turned down on the ground of lack of requisite qualifying service, he approached this court earlier through a writ petition being WPA 20340, where there is an order dated 30/9/2024, which makes the entire selection process subject to the outcome of that said writ petition. This has been, there has been no suppression, as my learned friends pointed out on the last occasion, that there have been suppression, and the order that I'm trying to derive benefit from, allegedly the state petitioner there has filed multiple applications. That is not the case. This is, and prima facie in the mandamus appeal, my lord, it is even in the mandamus appeal from the dismissed writ petition, prima facie an arguable case has been made out. It has pointed out. So arguably, even if I, for the sake of argument, even if I assume that my case squarely falls not within the factum and the circumstances of 20340, and it perhaps it comes under 5751, which is the dismissed writ petition, but the mandamus appeal will go on to demonstrate that even there is a prima facie case has been found. Now, my lord, the note that I've shared, I think that points out very clearly that what the similarities and the dissimilarities in these two writ petitions are.
Give a copy to your learned friends also. Are both of you appearing for the same authority?
Yes, sir.
Yes.
So, my lord, if my lord comes to the third row, the factual basis, the second and the third row, the nature of the grievance and the core dispute. In the writ petition 20340, where notice has been issued, and in 5751, the issues are separate, my lord. It is very clear. Because clause 10 of the recruitment rules.
What is the challenge over here?
I am challenging clause, my lord. I am challenging, at the very instance, I am challenging the impugned employment notification, which is the notification dated 10/7/24. This is my first prayer. If my lord comes to the prayer portion, I have also sought directions for granting appropriate weightage to the post of Group A category. But that is my prayer B.
The petition was filed in July.
Yes, my lord.
25.
I will address my lord on the question of alleged delay which has been pointed out by my learned friend.
The recruitment notice it was 1 year back, July 24.
What happened, my lord? There is the recruitment notice granted. The recruitment notice was in July 2024. But on the earlier occasion also, my lord, I had placed before your lordship that there were several representations. In fact, one of the grounds which aggrieve me is the ground of the selection committee not being proper, and the selection committee not being proper only came to my notice on 23/4/2025, when the interviews were being conducted on 23/4/2025 and 24/4/2025.
What is the stage of the recruitment now?
My lord, I am given to understand that the recruitment has been conducted. Someone has been selected. Now, my lord, on the third question, which has been reflected in your lordship's order on the last day, that whether a 2024 notification can be challenged in 2026. If this is the question that is plaguing all of us, my lord, for want of a better word, I would like to place before your lordship a fairly recent Supreme Court judgment, I think, which squarely covers this question. There are two questions on delay. One is the alleged delay, and my case is squarely on
All right, let them file their opposition. I'll see. Please
Grateful,
come.
my lord.
Madam, one thing, my lord, I'd like to point out, my lord, kindly comes to, my lord, the prayer portion of both the writ petition, my lord.
I have only one writ petition.
My lord, 5751.
My lord, I do not have a prayer.
0340, my lord.
No, 5751.
5751.
And
this is prayer C, and my lord, the order which has been challenging MAT, my lord, the prayer A, my lord.
Prayer day of
With my learned
1606. This writ petition and the writ petition and which has been dismissed.
Very
is the
well, you
same.
take a ground in the opposition, it will be seen. As it is, the recruitment is over and the
86, my lord.
it is there in the writ petition itself. All right.
I think my learned friends are pointing out to the other writ petition. Mine is 16060.
My lord, that is page 86, my lord, annexure T7, my lord. Results of election.
The petitioner challenges a recruitment process which was initiated in terms of the recruitment notice dated 10th July 2024. Stop. The learned advocate representing the respondent submits upon instruction that the recruitment process is long over and appointment has also been given to the successful candidate. Paragraph. According to the petitioner, there are gross illegalities in the said process. Paragraph. For taking a decision for proper adjudication of the list, the respondents are directed to file. Will you file a report or an opposition? Prepare. Let a report by way of affidavit be prepared and circulated within a period of 6 weeks. Exception, if any, may be prepared and circulated within a fortnight thereafter. Stop. Liberty granted to the parties to mention the matter for hearing immediately on completion of the aforesaid time period.
My lord, in this matter, last occasion, my learned friend filed a report. My lord, I have received it, my lord. My lord, there is some allegation. My lord, I should have to take an exception, but I could not press. If your lordship permits me, I can file the exception within.
All right. Learned advocate for the petitioner seek
Well,
time to file exception to the report filed by the respondents. Yes?
Next week or next 1 week.
Yes, yes. Let the exception be prepared and circulated by 17th of April.
Yes, yes.
Released on 27th April.
Much obliged, Your Lordship.
Yes.
No, I'm for the respondent, ma'am. You can the last order. 23rd March.
You can also leave. The other side is not there.
But I am here for some reason. Pilot knows that.
I understand that. Why you are here.
No, I should not say anything. What day I said,
This is for default record appearance of all the
day I said something and that has been viral before my lord.
They have not filed
I
any
will not say
exception.
anything.
They have not filed any exception.
ছেড়ে দিন আরো তো বলার কি my lord can remember that matter where so granted 6% interest bank said this is interest rate that matter.
Yes, Nick.
35, my lord, 34 and 35 also, my lord, I am for the petitioner. My lord, here also last occasion one report has been filed, my lord, I need some time to.
No.
Yes, I have given a
time was given to produce the report.
Yes, yes, original report.
Where is this?
I cannot, my lord, keep it before the court. I have to return that.
All right. Time to produce the report in terms of the order dated Atho is extended till 7th of April. This is the report relying on which his applications stood rejected. DME or what?
Yes, in stage of RME.
RME.
Challenge my lord duplicate report, my lord. That is why my lord.
In compliance with the court sorted.
Some illegible copy was there. That's why the original directed to produce the original.
Can you please read what is here because I cannot read it. দেখান তো কি বলেছে? Is a photocopy of this report here?
No. Original report, my lord. Photocopy was my lord. Earlier, my lord submitted.
Oh, photocopy is submitted. What does it say?
Hyper.
It is relying on this. It is the same thing. R3, it is here.
Same thing. My lord, same thing.
We concur with your finding. So what remains?
No, the burn.
The burn.
Burn. The scar mark on
Yes.
the left thigh.
That is also.
That is there. That is there. But as
Yes.
per the guideline, it should be more than 40% of body surface. That's why it has been written that it is not. It will not hamper any duties. Last line, my lord.
That is for the general
Last
people,
line.
my lord, but not for my lord the
General people, other people.
my lord force.
If their medical guideline is there, it is not the case that
Where
there
is
is no
the
medical
guideline?
Yes. This is the guideline. Kindly come to. Your lordship has the copy, my lord, I think. Your lordship can kindly come to page 32. Bottom portion, page marking is there, 32. No.
Yes, copy is annexed over
Yes,
here. I
copy
can
is,
see.
I think that is not the full 2 pages copy. Yes, there is copy is there.
Yeah.
My lord, yes. My lord, the
Elaborate
15, clause 15. Next, last page in report.
Yes.
Clause
Prior burn
15.
injury involving a total body surface area of 40% or more is disqualified.
Yes, that is the reason. It is 23 meters into 5 meters. They have indicated in the medical rejection order itself.
Page.
My lord, it cannot. My lord, page, that is page, my lord. In the this report also.
Yes.
My lord, prior to that report, this is annexure R2.
Annexure R2.
Annexure R2.
Yes.
That is the post burn
23 into
fiber
11.
graded, that is the 23 into 11 centimeter.
Yes.
On thigh. Total body surface can it be, my lord? I am height of 170, more than 170 centimeter. That's why I appeared before the.
Reviewed, my lord. In reviewed, my lord. Your lordship kindly see the page.
Yes,
27.
that is that order. That is I am showing. That is I am showing.
Reviewed and it is also unfit, declared unfit.
Unfit. What is the reason? This is the
Post-burn
hypertrophic scar.
Scar.
This is the post-burn hypertrophic scar. Right.
On account of.
And it was done in my childhood days.
Reason was they are unfit on account of post-burn hypertrophy. That is, my lord, not for my lord.
But you can disqualify only if this burn injury is more than 40%.
40% of the body
Where is
surface.
the finding that it is more than 40%?
Deeply obliged, your lordship.
Total body na khali ওইটুকু particular portion সেটা দেখো না
No.
40% of the total body surface area or that
Total body surface area.
Means the total for body.
It is mentioned involving total body surface area.
And
Then,
moreover, my lord, kindly come to page
and
20.
area is also mentioned in the review medical examination report.
That is
please come.
Deeply obliged, your lordship.
Original of the medical report annexed as R2 and R3 produced before this court. Stop. The court has perused the same. As produced before this court, by the learned advocate representing the respondents. Stop. The court has perused the same and returned the same to the learned advocate representing the respondents.
My lord, with me, my lord, online, my lord, my junior is also appearing in this case.
Nowadays, it should be recorded.
All right. Learned advocate for the petitioner points out that the area of the scar, as mentioned in the review medical examination report, is 23 into 11 centimeters approximately. Stop. As per the guidelines for recruitment medical examination, comma, prior burn injury to include donor sites within bracket, involving a total body surface area of 40% or more is disqualifying. The area of the scar, as mentioned in the review medical examination report, does not specify as to whether it is more than 40% of the total body surface area or not. Stop. The report, now the expert report obtained from the Department of Health and Family Welfare, College of Medicine and JNM Hospital, Kalyani, Nodia, also does not mention as to whether the scar involves more than 40% of the total body surface area. Stop. The respondent authority is directed to file a further report clearly disclosing as to whether the area of the scar is such that the same will stand as a disqualification of the petitioner for being engaged in CAPF. Stop. Let such report be prepared and circulated by 8th May, released on 18th of May.
Much obliged, Your Lordship.
Luck.
Thirty-five, may I please, Your Lordship, for the petition.
We have already posited.
My lord, they have given, my lord, here some allegation, my lord, 1 week time may be given so that I can take that.
Exception একটা বললাম না এর আগে,
Yes.
মানে একটা বললাম 32, same order.
Much obliged. Get good.
এটা কি একটা ডিপার্টমেন্ট লেখা রয়েছে অনিমেষ বাবু, এটা কি লেখা রয়েছে ডিপার্টমেন্ট? লিস্টে 35-এ লেখা রয়েছে ডিপার্টমেন্ট, লিস্টে 35-এ
কবে থাকবে? 27 রিপোর্টে লিখে।
My lord, one humble prayer, my lord, before starting the case, my lord. On the last occasion, reports were sought by your lordship. However, my lord, the reports are with my junior when I was not in Kolkata, my lord, and today he's not there. However, my lord, item number 35, 36 can be disposed of without the order also, without the report also.
All right.
And the rest, my lord, let us continue with the, I don't know, 36, thereafter I will say.
36, yes.
My lord. Here,
What is
CAPF
the requirement of a report?
My lord, there will be
report.
requirement of the report, my lord, but I think without the report is with my junior and is not.
All right, let me see. Understand. DME is which page?
My lord,
DME
Page 16.
16 is DME, bilateral deformity of the distal phalanges of
Index
both
finger.
the index finger. And the RME?
Same, my lord.
Same.
Thereafter, my lord, come to page 20, my
Deformity
lord.
of the body. Yes, then?
My lord, can't you come to page 20, my lord? The very first line, my lord. So, distal phalanges of both the index finger.
Appears normal. Metacarpal and carpal bones appear normal. Distal radius and ulna are normal. Everything is normal.
Rejection, my lord.
No.
Because
yes,
this should be taken as a ground for rejection, my lord. Because
no.
what happens, my lord, if your index finger is shorter during the combatized operations, my lord,
you will not be in a proper position
ma'am.
to hold the weapons.
Yes, my lord, certainly, and that is also elaborated in clause 2H of our guidelines also, my lord.
All right, yes. What is your submission, petitioner's
My
submission?
lord, page 20 on your lordship kindly sees.
Yes.
After the examination, this is the report. Patient is fit for regular duty.
Yes.
Now, according to their guideline, my lord, the ground for rejection that has been general grounds for rejection that has been indicated in clause 6.
Which page is it? Yes, clause 6.
Yes. In these clauses, there is no indication with regard to deformity of fingers. These are the only grounds by which a candidate can be refused. And
When if it is not there, my lord, I am covered by clause 2H of the guidelines.
Yes.
clause 2, human body may contain so many defects, deformities, that is not possible to list all clauses or unfitness in the medical recruitment instruction that may be militate against efficient discharge of service. Neither it is possible to list for thrilling cases where the candidates may be accepted or rejected. Recruiting manager needs to use the clinical acumen to the best of his knowledge and keeping in view of the best.
Tell me one thing, the example, the illustration that your learned friend has mentioned, you have a deformity in your distal fingers, right? If you are in the combatized force, regular duty means you are in the office, you are holding a file, it may not be difficult. If you are holding a machinery,
Machine guns,
then it becomes difficult. So I'm not accepting. আমাদের যে ইউজুয়াল অর্ডার আছে না রিজেক্টিং ডিএমই বলা আছে আরএমই অ্যাফার্ম করলো আর স্টেট গভর্নমেন্ট হসপিটাল অ্যাফার্মেশন রিআইটারেশন বলেছিলাম বোধহয় আমি রিআইটারেট গ্রাউন্ড অফ রিজেকশন আচ্ছা রেসপন্ডেন্টের বক্তব্যটা শুধু লিখে নিন 2H of the medical guidelines. আপনি এটা তৈরি করে দিন আমি দেখে নেব নেক্সট
My lord, on the next matter, my lord, I am speaking for not today, my lord.
There your learned friend is there.
There, my lord.
37 to 42.
37 to 42, my lord.
There is a direction for filing report I have not yet received.
Yes, he prays time. When?
But, I have no
Tomorrow.
objection, my lord, 1 week.
Only not today?
Only not today, my
Only not today.
Yes.
Last week you submitted, you will not be here this week.
No,
And every
six, up to 6, 1 and 2, I was not there. My junior was short for time. My lord, that's 6 was the monthly list. That's why I
thereafter
fixed them at 7 and 8.
I see every day you are here.
No, one.
All right.
30th and 31st, I was not there.
It's good. It's nice. No further.
Whatever.
Time.